statement by Minister on commemoration of International Youth Day, 18th August 2023.
Thank you. I have, colleagues, I've received a request from the Minister for Gender. They are hosting the president tomorrow in Kabare, so the whole team is already on the ground. So she has requested me to allow the government chief whip to present the statement of the ministry on her behalf, and this is allowed under rules of procedure. So, government chief whip, please. Maximum 10 minutes.
Thank you so much, Right Honourable Speaker and Honourable colleagues. Mr. Speaker and Honourable colleagues, I rise to brief you about this year's International Youth Day celebration, which will be celebrated on 18th August 2023 at Chigezi I Primary School in Kabale District. Honourable colleagues, you will recall that every year Uganda joins the rest of the UN fraternity on 12 August to commemorate International Youth Day. The commemoration of the day is consistent with the UN General Assembly Resolution 54/120 of 1999 that designated this important day of reflection and rededication to youth development. The day was designated for purpose of celebrating the youth potential and taking stock of what has been accomplished in the area of youth empowerment, growth, and development. The day provides us with an excellent opportunity to review our interventions, reflect, refocus, and strategize for the coming year. Honorable colleagues, this year we could not as a country celebrate the day on 12 August 2023 due to circumstances beyond our control. The theme for this year's commemoration is accelerating recovery from COVID-19 and full implementation of the 2030 agenda. The theme enjoins us to take stock of how young people's businesses have taken advantage of the micro and macroeconomic policies to recover from COVID-19. At the same time, we reflect on how we are faring in attaining the 17 Sustainable Development Goals. Right Honourable Speaker and Honourable Members, since the previous commemoration of 2022, the Ministry of Gender, Labour and Social Development has spent the bigger part of 2022 to 2023 consolidating the gains of last year, developing and designing programs aimed at empowering the youth and building their resilience amidst various economic shocks, trials, and tribulations. Among these include the following. 1. Initiating the development of National Action Plan on Youth, Peace and Security, consistent with the UN General Assembly Resolution 2250 of 2015. 2. Complete development of the out-of-school youth sexuality education guidelines. 3. Finalize designing of the National Service Scheme for Uganda. 4. Disseminating the National Coordination Mechanism for Youth Programs and setting up coordination structures at national and subnational levels. 5. Disseminating the national strategy to end teenage pregnancy and early marriages in Uganda. 6. Preparing the masses to understand and embrace the PDM approach to grassroots empowerment through mindset change. 7. Providing technical backstopping to programs aimed at holistic empowerment of the youth by implementing partners in the sector. 7. Previous events and government initiatives such as the Youth Livelihood Program has seen over 22,341 businesses financed to a tune of Uganda shillings 178,388,438,729 and benefiting 258,953 youth all over the country. OWEP, whose beneficiaries include the youth, has been accessed by 217,969 beneficiaries, supporting 19,723 projects to the tune of Uganda shillings 127,280,840,207 since their respective inception. Right Honorable Speaker and Honorable Members, we could have as a country done better, but we belong in the financial drought zone. We could not do any better than the call for financial irrigation. Right Honorable Speaker and Honorable Members, finally, allow me on behalf of the Minister of Gender, Labor and Social Development and the Government of the Republic of Uganda to invite you and all the honorable members of Parliament to Kabale and specifically Chigezi High Primary School for the national celebrations of the International Youth Day tomorrow, 18th August 2023, starting at 10 a.m. And His Excellency the President of the Republic of Uganda is expected to preside over as the chief guest. Right Honorable Speaker and honorable members, I beg to submit. Thank you.
Thank you, Honorable Minister. Honorable colleagues, this statement as provided for under Rule 52, Sub-Rule 2 of the Rules of Procedure, I may allow debate, and I would want to allow debate. But in a situation whereby all ministers are not around and they've really given us cause as to why they are not around, and it is for information purposes, I think it wouldn't do any harm if the celebrations can go on. Then on Wednesday, I give it 1 hour on the order paper and we debate it. Okay? Because the government chief whip won't be able to commit on issues that are not under his docket. Okay? So I'll provide for space on Wednesday so that we can debate it when the ministers are here. So Government Chief Whip, inform the Minister for Gender to be here on Wednesday. And we have a debate generally on the issues. Yes, no, but I had Mhono Mwijute first. Okay, you shared.
Thank you, Mr. Speaker. Mr. Speaker, I'm the Vice Chair of the Government Assurances Committee. And we've given a number of reports from our committee to the clerk, but they are not given space on the other paper. And the committee we are running is about promises of government made on the floor of Parliament. I wonder why we might be rendered a weak committee, yet our performance is fruitful. I pray that this is almost that. I think this is the third time I'm raising the same matter. Why our reports are not tabled by, are not given a chance of going on the other paper. And Mr. Speaker, still I have a challenge in the committee. There is an investigation we are making on compensation of war victims in Acholi, Teso region, where we visited. And you have given us very good funds to go for field work because ours is evidence-based after interfacing. When we went to Acholi region, Lango, Acholi, Soroti, we saw a number of people were compensated by the records were not clear. And we are seeking for your permission.
No, I haven't allowed him yet.
You see, I want to respect him as a professor, but he must have read the rules of procedure. Where you have a procedural matter, you can't have both at the same time. But a professor is a professor, Mr. Speaker. So, Mr. Speaker, we are seeking for intelligence. We went to the field, but at another time I will seek for intelligence to allow us to give these lists of people who are compensated so that the people at the locality and the districts can look at those people who were compensated where they're joining people. The little research we did and the number of people we met, they were not the right people. But we got them from the Attorney General. But above all, is our committee report reporting. Because, Mr. Speaker, in the previous Parliament, they were just tabling reports of evidences. But we have done our work, and my members are asking why our reports not being tabled so that they are debated by members and they give more information on what we find on site.
Thank you,
Mr. Speaker.
Yeah. No, Chair, you should have come to my office, okay, and raised this issue. we could have done better. But I understand your issue. Only that this week I had given priority to this very critical bill, the narcotic drugs bill, after the other one had been annulled by court. It's a very, very big crisis. But next week, I'll give you space.
Most obliged, Mr. Speaker.
Yeah. Please, clerk. Procedure Tebandeke.
Thank you, Right Honorable Speaker. Under Rule 87, the decision of the Speaker or the presiding chair becomes an order observed in the proceedings of the House. Right Honorable Speaker, 2 weeks before recess, I raised an issue against the government failure to sign a trade protocol between Uganda and China to smooth the transaction in fish meals, which has created a decline in the performance of stakeholders. Right Honorable Speaker, by record, between 2018 and 2022, Uganda had about 35 fish meal processing facilities.
What is your procedure matter, Honorable?
As I raise my procedure issue.
Procedure, you don't need to go into history. What is your procedure matter? It's straight.
Right Honorable Speaker, is it procedurally right if we do proceed and the front bench is violating the decision of the Speaker, who had commanded the Minister of Internal Affairs to come and report here in 2 weeks' time? And I waited by Tuesday as we resumed yesterday, even today. The Minister of Internal Affairs is not around, but you committed the Minister of Foreign Affairs, but you committed the Honorable Government Chief Whip to take on responsibilities. Isn't it procedurally right that by your power under Rule 87, you commanded the Sergeant at Arm to look for where the Minister of Foreign Affairs, wherever he is, to come and give a response? Because stakeholders' business is declining, yet they are the taxpayers.
Thank you. Now, Honorable, sometimes you are safer raising your procedure matter without referring to its rule. Okay? But, you see, foreign relations are matters of the executive. We can only guide. Here, this parliament cannot order government to go and sign an agreement with another country. No, we don't have that power, Honorable colleague. And I want it to go on record. And I want it to be repeated. We don't have that power. Okay? That's the work of the executive. So, if you had indeed asked that why doesn't the minister come and update the House only, I would understand. But now you want me to even arrest you. Want me to, and I can understand you're raising a very critical issue, Honorable Minister. So, Government Chief Whip, please ensure that the minister comes and updates the House on the issue raised by the Honorable Member, if that commitment was done, okay? Yeah, let the minister come, and I hope when he comes, really, he won't feel threatened that he will be arrested here. Yes, Honorable Gilbert. Colleagues, I want us to move. We have a lot of business to handle.
Thank you, Right Honourable Speaker. Right Honourable Speaker, much as you have given your ruling on the statement presented by the Honourable Minister about the Youth Celebration Day, Right Honourable Speaker, I thought the essence of this day, the report is presented when the day is still ahead, so that members could discuss, give in their opinion, so that during the celebration, the big people attending the celebration have some message to give to the youth.
Thank you.
I would like to seek your guidance, Honourable Speaker, if it is procedural okay, so that we discuss when the date is still ahead, than after, when the day has already gone.
Thank you. Now, Honourable, you have said that the purpose of that discussion would be for us to give our views so that the big people can pick a message to give to the youth. But the people who are going to speak on that, they are not here. That's why I've not put, they are not here. And you could understand, Kabari is very far. You can't say really you attend Parliament here, then tomorrow you be in time in Kabari for the celebration. So this is an information paper. No resolution is made on it. I think we shall even have an enriched discussion, because now we shall have heard their speeches, we shall have heard the speech of the president, and we shall be able to dissect all that has been said. But if they were here, and the budget used, by that time we shall know how much has been said. Okay? Yeah. Otherwise, I would have loved indeed that, yeah. No, Honorable Sechkubo, you have just entered. No, please, you have just entered. Honorable Christine, no.
Thank you very much, Right Honorable Speaker. Thank you very much, Right Honorable Speaker. With reference to your ruling, I only wanted to make an observation. YLP is one of the programs that has benefited a number of youth in the country, as indicated.
No. Please.
I only wanted to request, Honorable Speaker, that they also add on the gaps, the recovery gaps in terms of amounts of money.
That's what we shall debate on Wednesday. That's what we shall handle. Please, Honorable colleagues. Yes, Honorable Morris Procedure.
Thank you, Right Honorable Speaker. Right Honorable Speaker, in line with your guidance, since the Minister himself or herself will be there, I don't know, will be presenting that day, couldn't it be procedure right through your office that the Minister, as he or she is presenting, gives us a more enriched statement than what the Chief Whip read, because we expected something bigger than that. So couldn't it be really procedure right so that as he or she comes to present, we are more information is given as far as the development of youth and those programs are concerned?
Rich is a relative statement. Okay, what if this is what the minister has? We reopen her head and put in more and say then now go and serve it in Parliament. Okay? Yeah, I think what is very important, when we are debating, you pick out what you feel are gaps and you bring them out. That's the purpose of debating, okay? Otherwise, if she satisfies us, all of us at once, then no need for debate, okay? Thank you. Now, honorable colleagues, before we go to item 4, there is an item which is ready, and Parliament had handled it, and the committee was requested to go back and make some few revisions. So I would want us to handle that item number 6 before I go to item number 4.
Item number 6 on the order paper, motion for adoption of the report of the Committee on Finance, Planning and Economic Development on the microfinance deposit-taking institutions, in brackets, revision of minimum capital requirements, instrument 2022.
Chair.
Right Honorable Speaker and Honorable colleagues, indeed, like the Speaker has said, this report was already made by the committee. However, there was a minority report over one issue, which was about the minimum capital requirement for the MDIs. And the minority report was requesting that we consider 2 billion, whereas the main report had proposed 10 billion. Right Honorable Speaker and colleagues, I want to tender in the minutes of the reconciliation process, and also to report hereby lay, and also to report, Right Honorable Speaker, that in the process we invited, in addition to the methodology we had used, we invited the Association of the Microfinance Deposit-Taking Institutions of Uganda and also the Uganda Cooperative Alliance. And therefore, allow me to go straight to the observations and recommendations. Right Honorable Speaker and colleagues, when we considered the position that the minority report was considering, following the issues that we discussed and came up with. The observations are that majority of the microfinance institutions are still operating under Tier 4. And these institutions are not legally allowed to take deposits. In order to enhance financial inclusion, there is need for a legal regime that enables the majority of the microfinance institutions to mobilize deposits. And currently, there are only 4 MDIs in the country with a very limited footprint and branch network in the country. And the committee observes that since the MDIs vary in size of their balance sheet and shareholding value, in order to ensure equity among the MDIs, especially the aspiring Tier 4 institutions, the minimum paid-up capital requirement should not be a one-size-fits-all. Instead, it should be premised on a pro rata basis, that is, the size of the balance sheet of an MDI and that of a Tier 4 that is aspiring to be an MDI. Therefore, the minimum paid-up capital requirement of the MDI should be a function or a percentage of the balance sheet of each MDI. And the Bank of Uganda should therefore annually review the proposed instrument within 1 year and determine the right percentage of the minimum paid-up capital requirement, which would determine the percentage. In the meantime, the minimum capital requirement for the MDIs that we interfaced with, the 4, seem to be comfortable with the 10 billion. However, the committee observes that considering the Section 110 of the Tier 4 Microfinance Institutions and the Money Lending Act 2016, which brings the Tier 4 institutions under the control of the central bank, if the minimum share capital is above 500 million shillings, the minimum share capital should therefore be above 500 million shillings. And therefore, the increment in the minimum paid-up capital for the MDI also affects them. This will, in effect, affect their organic growth in light of the proposed stringent capital requirement. And therefore, the committee recommends that a harmonized position of a minimum paid-up cash capital requirement for a microfinance deposit-taking institutions be set at 250,000 currency points and be reviewed year after year. Right Honorable Speaker and colleagues, this would mean that the minimum capital requirement position that was reconciliation is 5 billion. And we also recommend that within 9 months after approval of this statutory instrument, the Ministry of Finance, Planning and Economic Development presents to Parliament a proposal for the minimum paid-up capital requirement of the MDIs to be determined as a percentage of the balance sheet value. Honorable members, here the point is, it shouldn't, like we said, it shouldn't be a one-size-fits-all. And since
Honorable Chair, you're not debating, you're reading a committee report. Please.
Much obliged, Right Honorable Speaker. The Minister of Finance, Planning and Economic Development should review Section 110 of the Tier 4 Microfinance Institutions and Money Lenders Act 2016 and Section 2, 4 and 7 of the Microfinance Deposit-Taking Institutions Act 2003 to ensure that the regulation of the Tier 4 Microfinance Institution is aligned. There is a typo there, it should be is aligned. In Tier 4 microfinance institutions under the control of the central bank as per Section 110 of the Tier 4 Microfinance Institutions and Money Lenders Act should be exempted from this statutory instrument. I hereby submit, Right Honourable Speaker.
Thank you. Thank you, Chair. Now I can see Honorable Chivumbi didn't sign, however much say he agrees, so I need to confirm from him. Honorable Chivumbi.
Right Honorable Speaker, thank you for the opportunity. Right Honorable Speaker, you know, earlier our position was that 2 billion would suffice. But when we went to the committee and listening to the plea of Bank of Uganda, Ministry of Finance, and other, the middle ground was that for now we can live with 5 billion, which the chairs elaborately put forward in the report. So largely we agree with the position as presented by the chair of the committee, much as I didn't, but it's up to this House to see through if that is fair, and then they can take a decision. But 2 takeaways, Right Honorable Speaker. One, that given what is happening, our sovereignty remains at hazard for as long as we are not able to mobilize the local deposits. Now, the difference between MDI and Tier 4 institutions, that these Tier 4 circles are not deposit-taking institutions. So my mother, my voter, those other people who go to the other market and sell their cattle cannot deposit their money in the evening in a Tier 4 institution. And therefore, that's why we are making a point. If we don't deepen the reach of Tier 4, a lot of monies will remain in the community and immobilized. I mean, if we don't encourage institutions that can receive deposits to go to the farthest point of our country, a lot of our people will continue to have their money in their bedrooms, and that non-mobilized money deprives us of money we can lend to business to grow the economy. Therefore, we think when we finally come back after a year's review, we shall have an eagle eye to see even whether it wouldn't be prudent to bring that 5 billion still down, to deepen the reach of people who can deposit their money every evening, every day, in order to mobilize local resources. The other one is the continued domination of financial institutions by foreign agents. How can Mama Mboga, the money lender selling tomatoes, be capitalized, be loaned money by a Muzungu? How? And the other day they will impose us all manner of conditions. Therefore, it is important to encourage local indigenous investors to go into the space of money lending. That is how we shall secure our sovereignty. I beg to move, Right Honorable Speaker.
Thank you. But now the principle is very simple. Whether you're a foreign bank, whether you are an indigenous bank, the deposit of your client is critical. When you lose money, losing money is losing money. You don't know whether it's because it was for a foreign bank or a local bank, you've lost money. So it's good we struck that balance, but that's a very, very critical point for us to protect our depositors. Honourable Minister, do you agree with this position? Do you think it can suffice for now?
Mr. Speaker, I want to thank the committee and the Shadow Minister of Finance for coming up with this middle ground. Would have preferred the 10, but since we can't get it, the 5 is good enough. I therefore agree with the position.
Thank you. Colleagues, this is a matter which was handled, it was debated for long. I now put the question that the report of the Committee on Finance, Planning and Economic Development on the microfinance deposit-taking institutions, revision of minimum capital requirements instrument 2022 be adopted. Those in favor say aye, and to the contrary nay. The ayes have it. Thank you, committee. Thank you, Honorable Chivumbi Shadow Minister. Thank you, Honorable Msasiza and Honorable colleagues. Clerk, extract a copy of the recommendations and the resolution and the answer and transmit them to the relevant agencies. Next item.
Item number 4 on the order paper, Bills Committee stage, the Narcotic Drugs and Psychotropic Substances Control Bill 2023. Clause 26.
Chair.
Right Honorable Chair, Clause 26 concerns service of notice of application for restraint order. Clause 26 is amended by deleting subclause 4. And the justification, Right Honorable Chair and Honorable colleagues, justification 1. Clause 26.4 contravenes Clause 23 and the spirit behind the issuance of a restraint order by converting restraint proceedings into proceedings of attachment of a person's property before conviction of an offense. By their nature, restraint proceedings only prevent dealing in property and do not act as an attachment of property which is dealt with under forfeiture provisions. Second justification, the provision goes beyond the spirit of a restraint order, which is prohibit dealing in the property when criminal proceedings are pending. Third justification, attachment of property is allowed when there is a final decision of court. Right Honorable Chair, I submit.
Honorable Minister.
I concur with the amendments.
Thank you. Colleagues, yesterday, you remember, we emphasized these provisions that either give court power or take it away. Sometimes they are not necessary. Whichever way court has already that jurisdiction. I now put a question that Clause 26 be amended as proposed. Those in favor say aye to the contrary nay. The ayes have it.
Clause 26 as amended.
I put a question that Clause 26 as amended stands as part of the bill. Those in favor say aye to the contrary nay. The ayes have it.
Clause 27.
Chair.
Right Honorable Chair, Clause 27 is a restraint order. For Clause 27, the Committee of Defense and Internal Affairs proposes that we be substitute the following and should read 27, restraint order. 1. Where an application for a restraint order is made under Section 23 and court is satisfied with the matters referred to in that section in relation to the respondent, the court may make a restraint order prohibiting the respondent or any other person acting on his or her behalf from disposing of, or in any way dealing with the property specified in the order or any interest in the property except in the manner that may be specified in the order. 2, without prejudice, subsection 1, a bank shall not pay to a respondent or any other person on the order of or on behalf of the respondent any money from sums held in any account by the bank in the name of respondent. Justification for this: 1, the restraint order only caveats any dealing in property but does not vitiate ownership. The purpose of the restraint order is to preserve the status quo. The property remains the property of the accused. Second justification, the proposal to transfer property of the affected by a restraint order to the official receiver has the effect of interfering in the proprietary interest of the owner of the property before the person is convicted of an offense. This goes beyond the effect of a restraint order. Third justification, and the last, this provision is therefore misplaced and should only apply where court convicts a person of an offense and orders for the forfeiture of property or proceeds of crime to the state. I submit.
Honourable Minister.
Honourable Speaker, the justification is sound and the amendments are allowed.
Thank you. Honourable Nandara.
Mr. Chairman, I want the chair to again assist me of the committee. Under the Constitution of Uganda, a government debt is the first call on anybody's account. Supposing this respondent had government tax, and you're saying anybody, and they want to get a debt for purpose of government, what will happen?
Chair. Thank you. Right Honourable Chair and Honourable colleagues, this law is only restricted to property that are considered proceeds of the crime of narcotics and phytotropic substances. It has nothing to do with whether you owe money. That is different proceedings in court.
I'm just saying, you have one account. It collects everything, including money from drugs. But at the same time, you have a business where they have assessed the tax, and the tax is due. If you pass it in this state, it means government will not collect this tax because you are saying anybody. And yet the law says a government debt is the first call on anybody's account.
Yeah, but Honourable Nandala, who is applying for this restraint order? It's the same government. Okay? It's the same government. And it is saying these are proceeds of crime, so don't take it away. You're restrained from taking it away from the bank until investigations are done. So the money is still with government. It is government choosing which way it goes. And I don't think government would want to benefit from proceeds of crime. We cannot protect the government, say, government, for you can benefit from proceeds of crime, but for you individual people, you cannot. So since it is all by government, let's move that way. I put a question that, yes, Honourable Jonathan?
Right Honourable Chair, my concern is that it's not far from his, except that where I am the respondent and I am sick and I need money for medical help, can't I apply to court so that it is now court that orders? And if it pleases the chairperson, he would ask that we would add that except on the order of court. Because if I have my money and I'm really seriously sick, and remember, you are still suspecting me, I am not yet guilty. This matter is before court, and I am sick. can't I just like these cases where we go and get our passports and travel, then you come back? So that court has some liberty and can even deal with the concerns that Honorable Nandala has raised.
Honourable Minister.
On the top of it, I would buy his argument. What if it is going to exhaust all the money that is being held?
No, you see, when it comes to matters of court, we can't limit court. And I think Honorable Jonathan is raising an important point, because court won't anyhow just go and allow this party to benefit from proceeds of crime. Someone can show that, look, I'm being frustrated. Someone has put this on me, I'm just being frustrated. For example, I'm going into elections, someone once broke my money, if I can say. But yeah, if I can be open to that. So someone can go and work on it, get an order, try to break your money. But I moved court, I said, no. There is no even so much evidence that is being given here. So if the discretion is from court Court is neutral in this matter. It's not taking any side. Honourable Minister, I would think that wouldn't be a problem. I need to get this on the floor.
Thank you. The concerns of Honourable Jonathan Odul and Honourable Nandala are covered in the subsequent clause of 29. This was for purposes of make sure your rights actually are not infringed.
I put a question that clause 27 be amended as proposed. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 27 as amended.
I put a question that clause 27 as amended stands part of the bill. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 28.
Chair. Oh no. I put a question that clause 28 stands part of the bill. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 29.
Chair.
Right Honourable Chair, clause 29 concerns the effect of a restraint order. Clause 29 of the bill, the committee proposes that be amended A in subsection 1 by substituting for the words transfer of the words dealings in. B by substituting for subclause 2A the following. I now read 2. Nothing in subsection 1 shall prevent court from enforcing a mortgage, charge, or any other transaction against any property in respect of which a restraint order is made, where the court is satisfied that A, the mortgage, charge, or transaction was transferred or executed before the restraint order was granted. B, a mortgage, charge, or transaction was created bona fide for valuable consideration without notice of the application referred to in section 23. And C, the person in whose favor the mortgage, a charge, or a transaction was created and registered was not concerned with or privy to the commission of a specified offense by the person against whom the restraint order is made. The justification for this, I beg your pardon, is to expand the provision to prohibit all dealings in land as opposed to prohibiting transfers in land as proposed in the bill, since the word dealings covers more than transfers. 2, in order to protect the sanctity of restraint orders from abuse, and to allow court to give effect to mortgages, charges, transactions that were entered into before the restraint order was made. 3, to harmonize clause 29 with clauses 23 and 24. I submit.
Honourable Minister.
I am advised to include what was D of clause 29 added, and it read maintained, and it read B.
Yeah.
The recovery of any revenue due to government, which I think is the point Honorable Nandala had raised, due to the government or a local government by sale of any property in respect of which a restraint order is made.
Okay. Would that suffice, Honorable Nandala?
Mr. Chairman, that one is okay. But now, what Jonathan raised, we thought it was covered. Now me, I'm satisfied.
Okay.
Now the problem now is sickness. Okay.
No, that one we covered it. We included the proposal of Honorable Jonathan Udur.
We did?
Yeah.
Okay.
The one of court. No, Honorable colleagues.
But there's another.
No, let me
text
guide
here.
you. Yesterday I guided properly. I said, unless we concede, okay? Unless I insist I call that we concede. When I put that amended as proposed, on a matter which a member raised and has not considered, that is part of the amendments carried. Okay? And then when they are cleaning the bill, when the clerk is cleaning the bill, he picks out all those issues in the answer. So Honorable Odur had proposed that we include unless directed by court, which we covered. Okay.
But Chair, I would like to now withdraw, having looked at clause 36, which is ahead. I think we'll take care of that.
Okay. When we are cleaning, we shall take it up. Honorable Guzuri, you had an issue in that?
I think my issue was that the exception provided by, alluded to by Jonathan was not clearly captured because it would infringe someone's right to medical care.
Okay.
Because that there would have been no prior charge.
Thank you. Any other, something different on this? Sorry? Yes, Honorable.
Thank you, Mr. Chair. Mr. Chair, my point here is regarding the A component where it said the mortgage, charge, or transaction was registered or executed before the restraining order was granted. Here I was thinking maybe we put a time period at least executed 6 months before the restraining order was granted, so that nobody, because sometimes people hurried within some few period of time, and then you find themselves registering. But if it is given 6 months before, then those hurry and corruptions that we know it exists in every corner may debar them. That's my proposal, Chair.
Chair? Why don't we leave court? Huh? Why don't we leave court with its... because we consider court to be neutral in this matter.
No, this is not about the court itself. I may be a culprit in that case. Then, if I've already seen ahead that I'm going to lose, few days before the court could have given an order, you rust, change the whole thing. After changing, then you come, they give an order, you find that the property is no longer in your name. But if it is 6 months before that time, those kind of dubious act would have mitigated it.
No. Honorable, please, we cannot work in futility. We cannot legislate in futility. Because if someone, for example, has already taken his money, has used it for other things, you can't come and say you took money 5 months ago, so you bring it back, we restrain you. You restrain what is available. You restrain what is available. What is not available, you cannot restrain it. Colleagues, let's move. We are going to rotate on many things.
Chair, I want to thank you very much. And you know, Chair, we can't legislate in anticipation, in a fear, in a vacuum.
Oh, you're done. So, yes, the Honorable Minister proposed that we reinstate B, we maintain B. So I put a question that clause 29 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 29 as amended.
I put a question that clause 29 as amended stand as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 30.
Chair.
Honorable Chair, clause 30 is the duration of restraint order. For clause 30, there is substituted the following. 30, duration of restraint order. Subject to this part, a restraint order in respect of any property shall remain in force until the restraint order is revoked by the court. A person may apply to court to revoke a restraint order on any of the following grounds. A, where the charges against the person in respect of whom the restraint order was made are dismissed or discontinued, or the person against is charged or acquitted, discharged or acquitted. B, upon death of the person against whom the restraint order is made. Or C, where the property in respect of which it is made is forfeited to the state. The justification for this, honorable colleagues and right honorable chair, is to expand the provisions relating to termination of the restraint order to include other grounds, including dismissal by court and the death of the accused person, which abates criminal proceedings. 2, to harmonize clause 30 with clauses 33 and 35. I submit.
Now, Chair, I would want you to clarify something small to me from your amendments. You mean if there was property you have and is suspected to be a proceed of crime, if you die, now your family should go and enjoy it? Your family should go and enjoy proceeds of crime? Because that is what your proposed amendment is saying. The moment you die, now the property is free. But it was a proceed of crime. And the same happens to corruption cases. We know the corruption cases here. They are accused who have died, but the state must go on and this is taxpayers' money. Honorable Nandara?
Yeah, Mr. Chairman, that is one of the things. Because even a family can kill a man and enjoy that could cause death. But what I also wanted to put on, I think, yes, they can decide that let us kill him or her to enjoy the proceeds of the crime. Because the law says it will be, or they can fit. But Mr. Chairman, there's times when somebody can, let me give you an example. The Attorney General has got a restraint order. He decides to use court with delaying tactics. And you stay in court for over 10 years and you may even die. Wouldn't it be important that also court can make a decision whereby if the state may have lost interest in the case or they are just playing delaying tactics to punish a person? Well, how do you cater for that? We should put something to deal with delayed justice issues.
Thank you, Chair.
Isaac?
Chair, I wanted the chair of the committee to try and clarify on the issue of, for example, properties owned by companies or by partners. Maybe the husband and the wife owns the property. In this case, how does it go in terms of restraining? That the ownership is not one person, it's a limited property, or secondly, it is home owned by the family, maybe husband and the wife.
No, that cannot apply here. The clause we are on is for duration. So I don't want us to bring other things beyond the duration. Yes, Honorable Jonathan, then Honorable Guzuri.
Actually, Right Honorable Chair, you have observed correctly. Under this subheading, we are dealing with duration.
Yeah.
So by introducing amendments raising grounds for revocation, we are mixing the spirit of that. So I wanted to persuade the chair to allow the clause stand as it is. Then when we go to 33, where revocation is provided for, those grounds then can be cut under 33, and also where necessary, we can then modify 35 as well when we get there.
Honourable Minister.
But the question of the Right Honourable Speaker remains unanswered on death terminating. Is it ahead?
Yes, under 33. We can handle it. We can. Yes, Honourable Guzuri.
I think it's important for expeditious trials or investigations or concluding the matter. A restraint order must revoke upon expiry of, say, like 2 years. That will place government with the responsibility to conclude these matters. Otherwise, there's a very big risk of someone using this particular clause or section as a political tool to deal with opponents. So I propose strongly that upon expiration, say, of 2 years, a restraint order must expire.
Yeah, colleagues, I think we can have this clause the way it is, okay? Because you see, what you're considering is that court is a neutral arbiter in the matter. You know, sometimes interfering with the works of court, trying to limit it, trying to, because like investigating narcotics, I mean, it's not easy. This is very, very complicated. This is a very, very complicated exercise. It's not a cup of tea. Okay? So, Honourable Chair,
Mr. Chairman, when you look at 33, a period of 30 days is actually provided. It's still ahead, but it takes care of the concerns that you can actually apply after 30 days. When a restraint order is issued, court will then entertain you.
Yeah, and it will listen to you, and at its discretion.
Yes.
Say, here you can, you can grant or you cannot grant. Okay. Yeah.
Mr. Chairman, your statement on the asset is very dangerous. When you say investigating drugs like narcotic takes many years, people will bring it that even the Speaker of Parliament said it takes long, and somebody will come and clamp your property and they say it takes many years when they're doing nothing.
Let me use the word, it's complicated.
Maybe that.
Yes, thank you. Honourable Chair, the proposal by the Minister that we retain the clause the way it is, then, yeah, you need to go on record. Yeah.
I concur with the Honourable Minister and beg that
Thank
we
you.
move on.
I put a question that clause 30 stands as part of the bill. Those in favour say aye, to the contrary nay. The ayes have it.
Aye. Clause 31.
Chair. Clause 31.
Right Honourable Chair, Clause 31 deals with offences in respect of restraint order. Clause 31 of the bill is amended by substituting for the words "for not less than" the words "for a period not exceeding." Justification for this, Right Honourable Speaker and dear colleagues, is in compliance with Section 37 ahead of the Section 37 of the Interpretation Act to prescribe the maximum penalties that may be suffered by a person convicted under this act. I submit.
Okay. I put a Honourable Minister.
Amendments allowed.
Thank you. I put a question that clause 31 be amended as proposed. Those in favour say aye, to the contrary nay. Ayes have it.
Aye. Clause 31 as amended.
I put a question that clause 31 as amended stands as part of the bill. Those in favour say aye, to the contrary nay. Ayes have
Aye.
it.
Clause 32.
I will request our IT administrator to mute everyone on Zoom, so that if you want to submit, you inform us that you want to submit, and then we allow you. Okay? But I want to appreciate the colleague who is very active. Yeah. Yes.
Clause 32.
Chair.
Thank you, Right Honorable Speaker. In the wisdom of the committee, having scrutinized the bill, they propose to this August House that we delete clause 32. Justification is that a restraint order only caveats any dealing in property but does not vitiate ownership. The purpose of the restraint order is to preserve the status quo. The property remains the property of the accused. 2, the proposal to transfer property affected by a restraint order to the official receiver has the effect of interfering in the proprietary interests of the owner of the property before the person is convicted of an offense. This goes beyond the effect of a restraint order. The provision is there misplaced and should only apply where court convicts a person of an offense and orders for forfeiture of the proceeds of crime to the official receiver. I submit.
Honourable Minister.
Justification sound, amendment allowed.
Thank you. I put a question that clause 32 be amended as be deleted. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 33.
Chair.
Right Honorable Chair, clause 33 deals with the exclusion of property, recognition of claims, and revocation of restraint order. Clause 33 is amended in subclause 4A by A, substituting for the word before the word after. B, substituting for the words complaint is made or information is. The words charge is preferred. The justification for this is for clarity to adopt a nomenclature used to refer to criminal complaints under the laws of Uganda, and 2, to determine the duration of the expiry of the restraint order. I submit.
Honourable Minister.
Allowed.
Thank you. I put a question that clause 33 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 33 as amended.
I put a question that clause 33 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 34.
Chair.
Right Honorable Chair, clause 34, there is substituted the following: where an application has been made to the court under section 23 for a restraint order, and the person against whom a restraint order is sought is charged with specific offenses, court may, on the application of the Attorney General or the respondent, stay the hearings of the application made under section 23 until a final decision is made in respect of the criminal charges. Justification for this is 1, to remedy an ambiguity in clause 34, since currently the provision is not clear as to the application it is referring to. I submit.
Thank you. Chair, Honourable Minister.
Would you, Right Honourable Speaker and honourable members, be wise to qualify the length of the stay, because it may go on forever, so I don't know.
So are we not wise enough?
You are, Right Honourable Speaker.
Yeah, he's making a humble proposal. And what would be your proposal, Honourable Minister? You know, when you go on the floor here, you propose. You don't throw a dice.
Right Honourable Speaker, still without trying to usurp the jurisdiction of court, I don't know whether we if we use the word reasonable time. Or 6 months to be specific.
Yeah, because you see, a court has a period in which it will determine the matter. Now, once we start interfering with this, I think yeah. So, Kanya?
We have other legislation where we advise court on time limits. So many of them, the common ones, the Parliamentary Election Act, we propose time. Time is very important, Honorable Mr. Chairperson, because, for example, if you are the owner of Sheraton and then you have restraint order, and the restraint order is a result of maybe $1 million, and then the period extends to create loss, and also to put pressure on the investigation institution to conduct investigation, conclude, and so that business can continue. Because Mr. Chairperson, as you know, as you said, it might be witch hunting and might affect other private business.
Honorable, this is stay of hearing of application.
Yes, so issues of 6 months is very important.
No, this is stay of hearing of application. The one you've used of elections is making a final decision. Now, this one, what if you're found guilty at the end? You know? So, colleagues, I put a question that clause 34, that clause 34 be amended as proposed. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 34 as amended.
I put a question that clause 34 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 35.
Chair.
Right Honorable Chair, clause 35 concerns the death of a person to whom the restraint order is made. In the wisdom of the committee, having scrutinized the bill, they proposed this August House that we delete clause 35. Justification. Clause 35 proposes to continue proceedings against an accused person who dies before or after a restraint order is made, in contravention of clear and known principles of law, that criminal proceedings abate or terminate upon the death of the accused, as was laid out in the case of R versus Senyonga, 1993, and that citation is there. The death of an accused person should terminate the restraint proceedings or orders made since the accused person has not been found guilty of an offense by court to warrant the continued attachment of his or her property. I submit.
Yeah. No, it's a principle, and again a very thin line, you know. Proceeds of suspected proceeds of crime, and for example, a crime like trade in cocaine that is in lots of monies, but again, a law is a law. Honourable Minister, are you having?
Thank you, Right Honourable Speaker. I would want to pray that we retain clause 35 because it is in respect of a restraint order made against the dead person, which passes on to the successor in title, and who can also apply for its revocation.
Yeah, because this is on property. Okay? This is on property, not the individual. We are pursuing that property. Yeah, so, Honorable Chair.
This bill remains a property of government, the responsibility of, and they are the implementers. I have absolutely no qualms in agreeing with him, but he should justify.
Mr. Chair.
Yes.
I wanted to hear from the minister why is, because the principle of law is well laid down, but why is this particular, retaining this contravenes the well laid principle of law? So I'd want to hear from the minister why we are coming up with something new contrary to the well laid out principles of law. If, however, I would want to hear from the minister.
Yeah, we can get other views, Honorable Minister, then you answer to one. Yes, Honorable Seungu.
Find out. It's unfortunate that Attorney General is not around. I am the owner of the property. I've died, but there's a case against me. I still have the presumption of innocence until I'm proved guilty. So if I'm dead, how would you proceed with my property when I'm not around? The principle is very clear, and I would wish the Attorney General to come in unless you stand over that clause.
Yeah, but Honorable Seung, in law school, you were clearly taught that for every general rule there is an exception. So, can we try to dig into that exception? Honorable Aisha?
Thank you so much, Chair.
Get your views.
This clause takes care of two scenarios. Where an application is still being heard in court and the person dies before a conclusion is made is different from where actually restraint order has been granted. Where it's been granted, we should go up to this person's wealth because court concluded well that person is still alive. But where the person passes on and that person is not available to be able to make a case for himself is a different situation. So for me, I want to appeal to the House that we go for that time when actually execution is not being done, the person dies off. When execution is not being done, we should go for the wealth of this person. But if hearing is still on, then there is no person to go against.
Yeah, but you see, Honorable Aisha, a restraint order is not a final. A restraint order is temporary on your property so that you don't move it. A final decision has not been made. They have not determined that this is a proceed of crime. Okay? So, Honorable Jonathan, yes, I'm going to allow you, colleagues. I'm going to allow you.
Chair, I would like to agree with the Minister. Yeah. And if you give me time, I'll cite that authority.
Yeah, sure.
There is an exception in the law, and I will cite that law, that the criminal proceedings can only terminate with the exception of property. Because the legal representative, whether you actually die or you are acquitted, once property has remained, it has to be dealt with in some way. So your legal representative should put a case before court on why that property should be lifted and given to him. So shortly I'm going to give you the reference here.
Sure. This is not like a crime against an individual of killing. Yeah, you say someone can take it over. It's the property. This is a suspected proceed of crime. So do we review it, enjoy it because you died? Honorable Nanda, then Honorable Sarwani.
Mr. Chairman, I think Jonathan has done it well. Even if it hasn't, even if he's still looking for the case. Mr. Chairman, this one has two implications. A person, if he discovers that this property wants to go to his hands, he can kill a human being because he wants it. It's very dangerous if we put it in the law. Two, we're dealing with a property which is suspected of a crime. Now, the person who is suspected of a crime has died. But the one who wants that property must come and prove that the person who died never committed a what? A crime. So, Mr. Chairman, any property which is dealing with
no, in criminal matter, the burden of proof is
sorry, I want to read that. Huh? That the person who owned the property until the state can prove that the person who died really dealt with drugs.
Thank you. Honorable Sarwani.
Right Honorable Speaker, even me, Right Honorable Chair, but still Speaker, even me, the paralegal, can clearly see that the presumption of innocence is always there before judgment. So there is no way Right Honorable Speaker would come up and put a law, because this is not the first law that we are making. There are other laws that are already standing on the same principle. There is no way we should pass a law as a House and say that they pursue my property when I have gone, much as, because how do you prove that it was the result of that crime or selling narcotic drugs? Because I've already died. So I strongly think
that we should not go for property. Because going for property means that, yes, honorable members, I want to implore you. Somebody has died when the trial is still going on. How do you prove? Because you are innocent until judgment is done in court and you're proved guilty, honorable members. So I want to implore you, honorable members and Right Honorable Chair, that we accept and we don't go for property.
Now, you got information? You got the information?
Yes, but
Yeah.
Chair, I think we are mixing it. The restraint order is not a criminal proceedings. It has to be clear. This is a civil matter.
Yeah.
So the question on the principles that apply to criminal law does not even arise.
Yeah.
And that is why I heard the procedure is by notice of motion and etc.
No,
So we are dealing with civil
Honorable Jonathan, you've made it very easy. That's why I was still... No, that settles it. That settles it. Because the proposed amendment is for criminal procedure. Under civil, property can still be pursued. And movement of property is a civil matter on all this. So, Honorable Chivumbi, you wanted to add on?
Honorable Speaker, I think we are dealing with the dicey matter. You do not want to take in law they call it the literal interpretation being given by our colleagues. In the way you are saying, first of all, this restraint order is interim for state to take steps to prove. So by the time it is existing, they have not yet proved that this property is a result of illicit drugs or illicit money. But then in the way you are saying that the administrator of my property, when I've died, should also somehow inherit my crime, because he has go to court and prove that this property was not a result of, and I'm not around. I find it very difficult for a parliament to enact such a law. It's very tricky. Right, Honorable Speaker, I would beg your indulgence and the minister to agree. Information.
Mr. Chairman, thank you, Honorable Member, for giving way. Let us be open, Honorable Minister. You know that people are smuggling goods in Uganda, and smugglers are very rich. They have been smuggling cigarettes, and they become rich. But after getting them, do you go to their property? Cross-border, you go to cross-border? Trade. But you know, even there's a member you normally call here, Honorable from Busia. So, Mr. Chairman, I think we have to be very careful on that. These people, smuggling has been here from Amini, brought Bobo Assos here in coffee, but property was not attached to the people.
Colleagues, all issues we are fearing for are covered for under subsection 2. Let us not only focus let us not focus on subsection 1 without looking at subsection 2, which covers all these fears and where court is having all this power. I put a question that clause 35 stands part of the bill. Those in favor say aye, and to the contrary nay. Aye. The ayes have it.
Clause 36.
I put a question that clause 36 stands part of the bill. Those in favor say aye, and to the contrary nay. Aye. Ayes have it.
Clause 37.
Chair.
Honorable Chair, clause 37 deals with forfeiture of property. In the wisdom of the committee, they had recommended that we delete clause 37, and justification for this is that clause 37 is redundant since it is a duplication of clauses 41 and 42 of the bill. The provision clause 37 has been incorporated in clause 42, which we shall read, and 2, the provision unfairly attaches all property of the person, present and future, irrespective of whether the properties were proceeds of crime or not. I submit.
Honourable Minister.
I agree for the deletion.
Thank you. I put a question that clause 37 be deleted. Those in favor say aye, and to the contrary nay. Aye. The ayes have it.
Clause 38.
Chair.
Right Honorable Chair, clause 38 deals with certain liabilities to the forfeited property. Clause 38 is amended by substituting the head note for certain liabilities to the forfeited property. B, by substituting for the words section 37 shall not, words the restraint order shall not affect. And the justification is consequential amendment as a result of deleting 37.
Consequential amendments, Honorable Chair, are dealt with at the end. Okay? So I don't know whether now I start going into consequential amendments. But since it is straight one, I think we can sort it. We go with it. Because we deleted 37.
Yeah, but Chair, legislation must flow. The only problem I have is that it is now a parachuting from nowhere, that specific one. Now that you recognize that you are dealing with forfeiture ahead, I would rather suggest that that specific provision be moved after until we have dealt with 30, I think
42.
Yeah, up to 42. Yeah. And then you bring that.
So let's do consequential amendments at the end.
Yes.
Okay?
Yes.
No, all consequential amendments. Okay? We shall move. Then after 46, we are very sure. We capture it, you note it down, okay? And then once we finish, we shall come back to consequential amendments so that we flow easily. Okay. So let's deal with it, okay? Let's deal with it, and then the clerk will take note of it. The moment we go up to 46 and we've agreed, then we shall maintain it. If we don't, as a consequence, we shall delete it, okay? I put a question that clause 38 be amended as proposed. Those in favor say and to the contrary nay. Ayes have it.
Clause 38 as amended.
I put a question that clause 38 as amended stands part of the bill. Those in favor say and to the contrary nay. The ayes have it.
Clause 39.
Chair.
Right Honorable Chair, clause 39, provision for payment of money owed. Clause 39 is amended in subclause 1 by substituting for the word section 38 the word section 42. Justification, consequential amendment as forfeiture is provided by clause 42. I submit.
But I don't know why your clerk didn't help you on all this so that we have consequential amendments later. But let's do like the way we've done the other one. We shall take note. In case we don't agree, we shall come back to it. I put a question that, yes, Honorable Nandara.
Mr. Chairman, I just want the chair of the committee to assist me. If you are paying this money, do you pay to the official receiver or you pay to government of Uganda as a consolidated fund? Because here what I'm seeing is say to the receiver, forfeit the receiver. Yet the money should be paid directly to the consolidated fund.
Honorable Chair.
Money that is paid as a result of court proceedings is what you mean? Because then it's paid to, it's according to the procedure.
Mr. Chairman, because the money you are getting is for the state, and the state has only one account, which is the consolidated what? Fund. The moment you put more hands as a court or whatever, this money may never even reach there. It may be diverted. So, Mr. Chairman, wouldn't it be better for us to say that all the money which is owed is paid directly to the consolidated fund to avoid
Honorable Minister, why did you consider receiver? But colleagues, do we even need to say where it should be paid? Isn't it? Because government laws, what if you change in future and you say this should be paid here? You know? Yeah. Yes. Well, what if you say it's paid to the state? Isn't it?
No, Chair.
Isn't it a standard where the money
Chair.
paid to the state goes?
Chair, we currently have a problem, if you look at Auditor General's report, where certain monies of civil nature and criminal are paid to account in court and other government institutions because they want to do reconciliation. And by the end of the day, some of the accounting officers mix this fund, and the government does not receive all what is due. So it's just proper that the law is very clear that this money goes to consolidated fund account.
Yes.
Chair, under clause 32, we deleted the official receiver. So there is no actually provision for appointment of the official receiver. So in this case, consequentially, where we have the official receiver, we can replace by state at the disposal of the state. Or whichever is applicable.
Honorable Minister, you want to say something?
Right, Honorable Speaker. Since property can't be under the consolidated fund, can't we retain official receiver?
Yes, clarification, Honorable Aisha.
Chair, I see a rehabilitation fund on 54. And it continues to say that proceeds that come out of forfeiture, they will go to that fund. I don't know why they have not even already allocated it to the fund.
No, you first of all, have we agreed to that fund?
But the proposal, because they say a portion of the property forfeited to the state under Part 4 as may be assigned to the fund by the minister responsible for finance.
Yes, but we've not yet agreed to establishment of the fund. Okay? But anyway, let's go with the proposal of consolidated fund to make it very easy. Because we have, I'm seeing money is going to government anyway. Okay, so you will, if we find any problem, the technical bench will advise and we can recommit that clause. Okay? Honorable, you had already submitted, you wanted a consolidated fund, and we are agreeing with it. I put a question that clause 39 be amended as proposed. Those in favor say and to the contrary nay. Ayes have it.
Clause 39 as amended.
I put a question that clause 39 as amended stands as part of the bill. Those in favor say aye and to the contrary nay. The ayes have it.
Clause 40.
Chair.
Honorable Chair, clause 40 is a claim by a person who commits a specified offense. Clause 40 is amended A in subclause 1 in paragraph A by inserting immediately after the word succession the words or that the property is held by him or her in trust for the benefit of another person. 2. In paragraph B, by substituting for the words relations, the words any person. In subclause 2, by substituting for the words section 37, the words section 42. C, by deleting subclause 3. Justification for this, Right Honorable Chair and Honorable colleagues, is consequential amendment arising from deletion of clause 37. 2, to include property held in trust among properties that can be freed from forfeiture. 3, to expand the list of persons who can gift property. 4, the deletion of subclause 3 is a consequential amendment arising from the amendment of subclause 1B. I submit.
Yes, Honorable Seungu.
Mr. Chairman, I pray that we make a small amendment on the notice in newspaper of wide circulation.
No, Honorable, in Parliament, we don't deal with small things.
Mr. Chairman.
Even a comma is big.
Yes, I'm saying let it be of notice in a newspaper of wide circulation. Not a newspaper alone.
Yes, I agree with you. Huh? Yeah, and the original text had it. So wide saturation is very important. Okay, Honourable Minister. Honourable Guzuri first, then Honourable Minister.
Yeah, Chair, I think while processing a similar law, we had such a challenge where we only have a mention of newspaper. I think the world is going digital, so it would be good that we address ourselves to media of wide circulation. It can be radio, it can be on internet, but to limit it to newspaper only would, I think, be counterproductive.
Now, one will even demand TikTok, another on social media. No, you must have a limit. No, you must have a limit. Honourable Minister? Yes. Yeah, you must have a limit.
Amendments agreed to.
Thank you. I now put a question that clause 40 be amended as proposed. Those in favor say aye, into the contrary nay. Ayes have it.
Clause 40 as amended.
I put a question that clause 40 as amended stands part of the bill. Those in favor say aye, into the contrary nay. The ayes have it.
Clause 41.
Chair.
Right Honorable Chair, clause 41 deals with procedure in respect of forfeiture. For clause 41, there is substituted the following. Procedure in respect of forfeiture. 1. Where a person is convicted of a specified offense under this Act, the Attorney General may, after conviction, apply to the High Court for an order to forfeit to the state any property owned by the convicted person that is ascertained to be proceeds of a crime under this Act. 2. Notwithstanding subsection 1, the Attorney General may apply to the High Court for an order to forfeit to the state any property held by any person that is ascertained to be proceeds of a crime committed by a convicted person under this Act. 3. The application referred to in subsection 1 and 2 shall contain a description of the property in respect of which the forfeiture order is sought. 4. Court shall, before making an order to forfeit the property of a convicted person, comply with rules of natural justice. Justification for this, Right Honorable Chair and Honorable colleagues, is 1. To streamline the process for applying forfeiture orders. 2. The amendment proposed in subclause 2 is for clarity and to harmonize the provision with clause 42, which duplicates the notices that are issued by the High Court. I submit.
Yes, Honorable Ekanya.
Thank you very much, Chair. I want to seek clarification from the chairperson, because I've been reading, we are talking about property, but when we are talking about proceeds of crime, we need to look at value. I know if you pollute one tomato can rot other tomato, but you have brought it very clear here, applying the rules of natural justice. That A, use proceeds of crime to complete construction of a property, and that property could be $1 million. And yet the proceeds of crime that has been investigated and established is just $100,000. How do we take care of, have you taken care of that when you talk about applying the rules of natural justice?
But colleagues, really, we're even going to educate on rules of natural justice. This is redundant. This is provided for in court proceedings. So the proposal under 4 is even redundant here. Yeah, let's do a clean bill. Yes.
I don't want to agree with someone's property who has been dealing in narcotics. Once you get him, you are taking him for reprimand. And when you take him for sentencing, you are shaping him. Now, this person is not corrupt, but he has been committing an offense of selling narcotics. Now, when you go to his properties and you attach them as government, it's not proper. That's not there. I don't know where it is in the world. You could guide us, Mr. Chairman. Otherwise, you are going to charge him in court. You know he got property worth $3 billion and is very rich, but he's going to be sentenced for 20 years. in prison, then how do you come and take property? You can't.
Thank you.
Let us look at that very carefully, Mr. Chairman. Then how is he corrupt? Because under the Anti-Corruption Act, it's clear you got assets out of government funds you stole. But this man was dealing in smuggling, selling narcotics. But he was caught. And when you take him to prison, you are shaping him. For 20 years, he's going to be under arrest. So what he has got, the proceeds, how will you manage to know that he got them from narcotics? Because I can get 5 billion from narcotics and I use them to invest in another deal somewhere else.
Okay.
Then how would you attach that property?
Thank you. But
it can't be.
But Honorable Sewungu, if you're saying property of the corrupt should be sold, okay? What about property from cocaine? As if you don't know the impact. Usually how they do their impact on community. I think the debate should be how you use proceeds, okay? How government would use money gotten out of taking of that property, confiscation of the property.
Respond. Mr. Chairman, under the Anti-Corruption Act, it is clear Sewungu was a civil servant. He stole money from government. And after getting his assets, they are touched by government because he got these proceeds, all wealth, through corruption. But he is a gentleman whom we have just discovered that is selling narcotics. He's not corrupt. Once you get him, you are charging him under the law, but not the property. Because you are going to sentence him. And he has people to live with at home. What if he put all these assets under the names of his children?
Honorable Minister,
how will you get there?
Then Honorable Kanusha.
I think what Honorable Sewungu is trying to do is to reframe the objects of the bill, because he said the following are what we want to achieve through this bill. Among others, the proceeds of sale of narcotic drugs and psychotropic substances. So if we don't go for them, what else should we?
Colleagues, narcotics destroy society. So if you want to destroy society, and then for you remain in your comfort and your family, they can come see you in Rizira in a Benz. They can buy you food of Serena and bring it to you because you're enjoying proceeds of crime. No. Honorable Kanusha?
Right, Honorable Speaker, I think you've said it properly, but I think just to respond to Honorable Sewungu, that also some laws provide that you can have both. You can be sentenced and your property can also be attached. And we have seen people who actually commit those crimes and say, for as long as I have left my family with 10 billion, I can go and sleep in Luzira. So for me, I think that we might have to consider either or even both, so that the discretion of the court can decide that if you have been selling, you can, the court can decide to attach your property and again sentence you for a period of time. But I don't think we should leave property for people who have committed crimes for their families to enjoy.
Thank you. Now, colleagues, when we are on committee stage and the colleague is submitting, please hold your peace for that time. This is a very sensitive stage. Okay? When someone finishes, then you can stand up. I'll give you a chance. Honorable Aisha.
Thank you,
Honorable Sandra.
Chair. I don't know, Chair, whether you're proceeding well, because we actually handled that matter yesterday. Under Clause 1, all the justification that is being given here was given, and the House agreed in unison that over and above the criminal charges, there should be forfeiture to the state. That is under Clause 1. If Honorable Sewungu wishes, he can recommit this Clause 1, and then we see what to do. It was handled yesterday.
Thank you. Honorable Santa.
Yeah, thank you, Mr. Chairman. Mr. Chairman, I'm not sure whether Honorable Sewungu was here yesterday, because we passed this and agreed as a House yesterday, and he's trying to use this chance to recommit in a wrong way. Mr. Chairman, this is a very big issue that we are handling as a country, with a very detrimental impact to our children. And for me, we should not leave people to enjoy the proceeds of this crime or leave it to their relatives and encourage them. Then what shall we be doing? It will be self-defeating, Mr. Chairman.
Thank you. Honorable Komakech.
Thank you, Chair. Chair,
the money that the dealer has gotten is actually unlawful money. He deals in narcotics that is unlawful to get the money. Meaning, it's not about prisoning him only. It's where did he get the money from? If the money is illegal, there's another aspect I would want to interest this House with. Dealing in drugs entails cartels. It's not about one man, as if it's selling of a shop. No, it's either a father and a group of more others. I would think this law taking away the money from the dealer would also limit the cartel members from participating in the trade.
No, I want to give others a chance. Doctor?
Thank you very much, Right Honorable Chair. Right Honorable Chair, you have already said that narcotics destroys society. And we know that there's a lot of money in drugs. And when people who deal in drugs, they get this money, they'll be able to invest it and acquire assets. I think the spirit of this law is actually to prevent dealing in drugs in the country. And therefore, I think we want to put measures which are deterrent enough so that people not get involved in dealing in drugs. And one of that is by taking the property. I think that's my take. Thank you.
Thank you very much, Right Honorable Speaker. I think when we are making the law, we make the law to make people aware of it, to not to do the bad acts. So at the end of the day, when we bend the law to favor people in another way of doing bad acts, then doesn't help. To me, I think the best thing is, if somebody has stolen the money, for example, and it is evidence that a person has gotten, took the money from the government, for example, the person can be convicted, and the property can also be attached. That makes a person to be very much aware that if I do this, this is going to happen. The Honorable has just mentioned it. This is very true. There are people who say, I'd rather steal 10 billion, I go to prison, my family enjoys. So at the end of the day, what does the law, how has the law helped us? So to me, let the property also be attached. Thank you.
I had allowed Dr. Pio.
Thank you, Right Honorable Speaker. I believe that the spirit behind this law is that you're taking the person to prison to rehabilitate them. But there are lives that you've destroyed that need to be rehabilitated. And there's a financing cost for that. And we've said that this money goes into the consolidated fund. So it is financing the rehabilitation of the lives that have been destroyed. But secondly, we've known of cases where people have gone to prison, but they're still operating their businesses in prison. We've seen cartels continue to operate because the person still has the funds in the account. So the intention is to cut off the whole cycle of the cartels itself. Thank you.
I put a question that Nambeshe.
Thank you, Mr. Chairman. Mr. Chairman, I realize that in this clause, we are likely to offend the doctrine of innocence. Because if attachment of property is left to the convicted person to prove that this particular property was lawfully acquired, isn't that shifting the burden of proof to the accused, which offends the doctrine of innocence?
Honorable Jonathan Odu.
Yes, Chair, my submission is actually different. First, I wanted to persuade the House to reject this amendment and go by the original text. If you read the original text, it's more comprehensive. After a person has been convicted, it provides a procedure where even other people, because after the conviction, the property that has been cited and any other property can actually be attached. The procedure laid in the original text, including publishing in newspaper, wide circulation, the property that now the state is interested, the Attorney General is going to take over. It gives any other person with a claim opportunity to come. So if the chair is pleased and the minister is paying attention, we are better off with the original clause other than substituting for what has been proposed.
Which limits to the Attorney General. Because you see, if that cocaine destroyed my family, I've been seeing it everywhere in America and all that Me Too movement, people coming up and making claims, some under public interest litigation. You know? Honorable Chair?
I agree with the proposed amendment.
I put a question that clause 41 stands part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 42.
Chair.
Right Honorable Chair, Clause 42 deals with forfeiture order. Clause 42 is amended A, by substituting for subclause 1 the following. 1. At the conclusion of the proceedings under Section 41, the court may, where satisfied that the property is a proceed of a crime under this Act, make an order for forfeiture of the property to the state. B, by substituting for subclause 2 the following. The forfeiture order referred to in subsection 1 shall specify A, the property to which the order applies, B, any mortgage or charge secured by or over the property, C, the property excluded from forfeiture under section 40, D, the property forfeited to the state, and E, the extent to which any property forfeited to the state is liable for areas of revenue to a local government. C, by substituting subclause 3 the following. The Attorney General shall, where a court makes an order for forfeiture under subsection 1, publish in the newspaper of wide circulation in Uganda and the gazette particulars of the property for which an order for forfeiture has been made. D, by inserting immediately after subclause 3 the following. A person who has title to any property or whom claims any interest in any property in respect of which a notice is published under subsection 3 may apply to court for release from forfeiture of any of his or her property within 30 days from the date of publication of the notice stating the particulars of his or her claim. Where the court is satisfied that the person making an application under subsection 4 has title to the property or any interest and was not a party to the commission of the specified offense or any other offense under this Act, court may make an order for release of the property from the forfeiture. E, by inserting immediately after the subclause 4 the following. Where the court has made an order for forfeiture of property under this section, the minister may, in consultation with the minister responsible for finance, sell the property forfeited to the state and remit the proceedings of the sale to the National Fund for Narcotic Drug and Psychotropic Substances Control established under Section 72 of this Act. Justification for this is for clarity to harmonize Clause 41 and 42 to specifically require court to make a forfeiture order. 3, to make provision for the recovery of property by persons who are not concerned with or privy to the specified offense with reference to which the application of forfeiture is made in order to protect the proprietary rights of innocent persons. 4, to merge Clause 37 and Clause 42 since they relate to the same subject matter. I submit.
Yes, Honorable Kanya, Honorable Guzuri.
Thank you very much, Chair. Chair, I want to request the chairperson of the committee, that is very important for us when we are making this law to look at other relevant acts we have in place. For example, the Public Finance Act is categorical. We forbid under that act creating any other fund. And we tried our best to make sure that all resources are consolidated to consolidated fund. Any organization is supposed to come up with a budget upon which they want to use to implement their program and request for money, and then we approve. Secondly, under the Valuation of Property Act, because we are talking about property, chairperson, this property needs to relate to the value of the proceeds of crime. And Mr. Chairperson, I really want to beseech the chairperson of Committee of Defense that property needs to be valued and related to the value of the proceeds of crime. And that clarity needs to be in the law. If you leave it ambiguous, under the Valuation of Physical Planning Act, suppose this is the land, the district council is supposed to pass the value of a property upon which, when you're handling civil and criminal matters, it will create ambiguity and conflicts. So we need to ensure that the chief government valuer really centralize the valuation of this property, and the value is standard. Number two, we need to be clear what is the value of the proceeds of crime that has been invested in this, and that needs to be guided here. But when we just say property, you leave a lot of room.
Honorable, we handled that issue yesterday, the issue of value. That was the issue of serious debate yesterday. I won't open it up here again today. We sorted. Honorable colleagues, in the public gallery this afternoon, we have pupils and teachers of St. Cosmas Bakijurula Primary School from Karungu, Masaka District. They are represented in Parliament by Honorable Seungu Joseph Gonzaga and Honorable Sechin Aisha. They've come to observe proceedings of the House. Please join me in welcoming them. You can stand up. Welcome you. Thank you. Colleagues, also, we have members of the Wakiso Mira Growers and the Dealers Association Limited, an umbrella body of the Uganda Cat Mira Growers and Dealers in Uganda. They've come to observe proceedings of the House this afternoon. Please join me in welcoming them once again. Thank you. Now, it's Honorable Nandala.
Mr. Chairman, I am on the National Fund for Narcotic Drug. Mr. Chairman, this fund, if you tend to make...
Honorable, that is under clause 70. I don't want us to discuss it now.
No, that's true. That's why I'm here.
Mr. Chairman, Honorable, I would guide, okay? If the questions are around that, don't mind. Let us handle the clause the way it is. Then once we accept or reject the fund, we shall have a consequential amendment.
Mr. Chairman, the reason, okay, I have no objection to it. Yeah. The only problem which I wanted to put clear here is that the money which you get, if we are saying it's going to the drug account, we're making a mistake. And that's why I want to concur with Honorable Ekanya. All the monies which are got from anything in the state go to the consolidated fund. I think what we would say, I want to ask the chair to agree that the proceeds of the sale shall be deposited on the consolidated fund.
Now, colleagues, you remember under 41, which Honorable Jonathan raised. It was the original clause was giving chance to even beyond the state for people to go and make a claim. Now, if I make a claim because your dealings destroyed my family and I want to be compensated, but you're saying everything goes to the consolidated fund, how will I get my claim? So since we retained 41, 42 and 43 need to be retained the way they are in order to rhyme with 41. But when you go with the proposed amendment which was rejected under 41, then that's when you would be having all these amendments. Okay? So, Chairman.
Read I
Thank
agree.
you. I now put a question that clause 42 stands part of the bill. Those in favor say aye, and to the contrary nay.
Aye.
The ayes have it.
Clause 43.
I now put a question that clause 43 stands part of the bill. Those in favor say aye, and to the contrary nay.
Aye.
The ayes have it.
Clause 44.
Chair. Oh, I put a question that clause 44 stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 45.
I put a question that clause 45. Yeah, 45.
Right Honorable Chair, on clause 45, the reading of the text is that where a conviction for a specified offense is set aside by court on appeal, the person whose conviction is set aside may apply to court for a restoration of the forfeited property. For me, I think we are going to build up more cases in court where it is not necessary. At this stage, that appellant court can actually give an order for restoration. So why should we now create another cost imposed to go and apply, and yet you're already before court? So I wanted to make an amendment that where a conviction for a specified offense is set aside by court on appeal, the appellant court may order for restoration of the forfeited property.
Honourable Minister.
I concede to the proposal.
I put a question that clause 45 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 45 as amended.
I put a question that clause 45 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 46.
I put a question that clause 46 stands part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 47.
Chair.
Right Honorable Chair, clause 47 deals with arrangement regarding tracing, realization, etc. of property in Uganda. Clause 47, the wisdom of the committee, they propose that be amended A, in subclause 2, by inserting immediately after the word by, the word statutorily. B, in subclause 3, by substituting for the words without reasonable delay, the words within 3 months from the date of the statutory order was made. The justification is to clarify what order the minister can make under clause 2, and 2, for clarity of provision to remove ambiguous words. I submit.
Honourable Minister.
Amendments allowed.
I put a question that clause 47 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 47 as amended.
I put a question that clause 47 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 48.
Chair. I put a question that clause 48 stands part of the bill. Those in favor say aye, and to the contrary nay.
Aye.
Ayes have it.
Clause 49.
Chair.
Right Honorable Chair, clause 49 deals with concealing or transferring proceeds of drug trafficking. Clause 49 of the bill is amended A, by deleting the word drug where the word appears in the provision. B, in subclause 3, by deleting the word no consideration or for inadequate consideration. C, by substituting for subclause 7 the following: a person who commits an offense under this section is liable on conviction to imprisonment for a period not exceeding 20 years. Right Honorable Chair and Honorable colleagues, justification for this is 1, the deletion of the word drug is to harmonize the provision with clause 2, which defines the word trafficking and not drug trafficking, which is used in the provision. 2, the amendment to subclause 3 is intended to prohibit the dealing in tainted property rather than prohibiting undervaluation of tainted property as proposed in the provision. 3, subclause 7 is amended in order to comply with section 37 of the Interpretation Act, which requires criminal provisions to prescribe the maximum penalties that may be suffered by a person convicted of the offense. Right Honorable Chair, I submit.
Yes, Chivoga, then Clark.
Thank you, Chair.
And Oguzu.
That means the naming of the clause should also change because it still has the word drug.
Chair, is that okay? On that one, are you okay? Can you repeat for the chair?
The naming of the clause, it still has proceeds of drug trafficking. So the name drug, the word drug should still be dropped from the naming of the clause.
I agree.
Thank you. That's Honorable Gilbert.
Thank you, Mr. Chairman. Look at the person who commits an offense. Why are we providing only provision for imprisonment? Can we provide provision of payment also, like in terms of currency, or both? Because from here you are providing only strictly for imprisonment. Mr. Chairman, I was looking at providing provision of payment in terms of currency.
Provided it's an addition to what is already provided. The idea is not to substitute penalty for fines. Otherwise, people will take it lightly.
Honorable Guzuri.
Under clause 1, I would like us to add the word knowingly. Any person who knowingly, because for you to be guilty of any criminal offense, you must really have intent. I've seen a practice in Dubai where people, Ugandans, send things to you and you're supposed to transport them. So you may not have idea what you are carrying. And it turns out that you have carried drugs and things like that. So we should be able to hold someone who knowingly does this responsible for the penalties and fines or charges that are therein contained. Thank you. So Chair, if you could admit that proposal.
Honorable Minister. Honorable Yume.
Mr. Chairman, I don't think there is any person who will come out and say, I knowingly transported drugs. It would be very hard to discern and prove whether he carried the drugs knowingly or not. I would think leave that to the discretion of court.
Thank you. With that, indeed, it's an implied term. So it's already, you carry drugs and you say, I didn't know. You must carry the burden. So, colleagues, and remind me, whenever we reach on any clause that has a minister, we must specify which minister. So you be alert. I put a question that clause 49 be amended as proposed. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 49 as amended.
I put a question that clause 49 as amended stands as part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 50.
Chair.
Thank you. Right Honorable Chair, Clause 50 deals with prohibition of holding illegally acquired property. Clause 50 is substituted for the following. A person who aids in the concealment, disguise, conversion, or transfer of proceeds of crime commits an offense and is liable on conviction to imprisonment for a period not exceeding 5 years. Justification for this, honorable colleagues, is 1, Clause 50 is ambiguous since it does not define what amounts to illegally acquired property. 2, the provision did not create an offense and prescribe a punishment. I submit.
Thank you. That's Honorable Jonathan.
Chair,
on clause 50.
Yes, on clause 50, I would move for a deletion. If you look at the amendments made by the committee in 49, it handles everything to do with the provision under clause 50, concealment and etc. So it will be a duplication actually. from the amendment they have just made to 49.
Sure. Honourable Minister.
Deletion considered allowed.
I put a question that clause 50 be deleted as proposed. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 51.
I put a question that clause 51 stands part of the bill. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 52.
I put a question that clause 52 stands part of the bill. Those in favour say aye, and to the contrary nay. Ayes have it.
Clause 53.
Chair.
Chair, clause 53 deals with rehabilitation centers. For clause 53, there is substituted the following: treatment and rehabilitation centers. The minister may establish a facility for treatment and rehabilitation of persons with substance use disorder in accordance with Medical and Dental Practitioners Act, Cap 272. 2. Notwithstanding subsection 1, a person may establish a private facility for treatment and rehabilitation of persons with substance use disorder in accordance with the Medical and Dental Practitioners Act, Cap 272. 3. The object of the facility for treatment and rehabilitation of persons with substance use disorder shall be to provide for the care, treatment, and rehabilitation of persons with substance use disorder. Justification: 1. There is a need for the minister to establish treatment and rehabilitation centers to increase access to medical treatment and set standards by all stakeholders providing treatment and rehabilitation of narcotic drugs, psychotropic substances, and any other related substances abuse. I submit.
Thank you. Now, colleagues, if you have a copy of the bill under 52, the whole of part 5, it's clearly provided that for interpretation purposes, the minister will be a minister responsible for health. So it's already provided for under the whole of part 5. Chairman, Committee for Health.
Substitute clause 53 for the following: treatment and rehabilitation centers. Subclause 1, the minister responsible for health may establish, designate, or approve treatment and rehabilitation centers for the treatment and rehabilitation of persons with substance use disorder. 2, the minister responsible for health may authorize a person to establish a private treatment and rehabilitation center for the treatment and rehabilitation of persons with substance use disorder. 3, a person who wishes to establish a private treatment and rehabilitation center under subsection 2 shall make an application to the Uganda Mental Health Advisory Board established under the Mental Health Act for accreditation of the treatment and rehabilitation center. 4, a person who has received accreditation under subsection 3 shall apply to the minister for authorization to establish a private treatment and rehabilitation center. The justification is to empower the minister responsible for health to designate or appoint treatment and rehabilitation centers, as well as regulate the establishment of private and rehabilitation centers.
Yes, Honorable Songa, and then
Yeah, thank you very much.
Dr. Boka Didi.
First, we may need to get the true meaning of establish. Otherwise, it will mean the minister is going to establish a new center. But the question is, currently, where are we rehabilitating the substance abusers? Thank you.
Honorable.
To that point, I would really propose that we can identify the current or existing rehabilitation centers, give them more budget so that they can also handle substance abuse.
Can you start with that, Chairman?
Thank you very much, Mr. Chairman. I would like to recommit clause 52 interpretation of part 5.
No, recommitment is done after we have finished. I wanted you to respond to Honorable Songa. As I understand, the current rehabilitation centers are not provided for under the law. Are they?
Under the Mental Health Act, the facilities under the Mental Health Act also do treatment and rehabilitation, among other things.
Mm-hmm.
Yes.
So what Honorable Songa is saying, that we already have them. So when you talk of establishing, so should we say the ones which are already existing will be provided for under the transition clause?
Clarification.
Yes,
Chair, this is a new phenomenon that we are dealing with. The only established center that does treatment and rehabilitation, the only one, is the Butabika National Mental Referral Hospital. The only one recognized. If I may, the other centers are privately established. They are so exorbitant, they are unaffordable. They charge a lot of money that is. So what this law intends to do is to give the minister authority to establish treatment and rehabilitation centers other than the national mental referral hospital.
Yeah. Honorable, I had allowed Dr. Boka Didi.
Yeah. Thank you, Mr. Chairman. I want to start by clarifying on the difference between establishment and a licensor. Under the Mental Health Act, Butabika is a health facility. And why we say this treatment and rehabilitation is because we consider this as health facilities. The authority that licenses health facilities is the Uganda Medical and Dental Council or any other allied health facilities following laid down criteria. That clarifies the issue raised by him. The second observation I want to make is in regards to the practice of treatment and rehabilitation. There's a third component that oftentimes is neglected, which makes many of the cases of people affected by drugs relapse, and that is the social rehabilitation component. That has acceptance within the community, but also preparing them to be able to have a livelihood for them not to fall back. That should be considered within this. So instead of having treatment, I would like to propose that we have treatment, rehabilitation, and social integration. Thank you.
Okay. Honorable Nakato.
Thank you, Right Honorable Speaker. Right Honorable Chair. I wanted to add on that most of these rehabilitation centers, whether private or government, Butabika has two, but they are not well equipped because we have we have classes of these casualties. Like a student may be brought and then he can be put on treatment. Then after a while, he stays as if he's normal, and then still he takes again opium. Then at a time, you can't take such a person to Butabika or a rehabilitation center. My proposal is that these rehabilitation centers are by the names, but the equipments and the care, sometimes you only find physiotherapists, sometimes you find psychologists, but not medics. I want to submit. Thank you.
Thank you. Yes, Co-Market, and then Honorable Agnes Tucker.
Thank you, Chair. It's better that I clarify. The entire Uganda has only one rehabilitation center, which is in Butabika. Now, it's so important that we differentiate between psychiatric patients and drug addicts who are attaining treatment. It's very important. Butabika has two units. There is alcohol and drug unit in Butabika. That is not for psychiatric patients. It's only for addicts, and it can accommodate only 50 to 60 clients for the entire country. There is no any other rehabilitation center owned by government in this country. When they come with the notion of establishment, the chair correctly states that that clause mandates the Minister of Health to go region by region or in whatever place to establish new rehabilitation centers for the treatment of addicts. Currently, if you go to Masaka Regional Referral, Ogulu, what they do, Butabika, Mawaso also, they combine mentally sick patients with addicts, which is wrong. But because of inadequacy of resources and staff, that is how our country is operating. I just wanted to clarify.
Thank you, Right Honorable Chair. Right Honorable Chair, laws are made as the situations are. And currently in our country, the rate at which the youths are abusing drugs is too high. Therefore, the issue of establishing, I propose that it should stay, but rather, maybe we have the minister shall establish, so that we have, yes, so that the minister has the authority to, we have a way of following up on the minister that it is a must to establish the rehabilitation centers throughout the country so that we have those services easily accessed by even the most rural Ugandans. Because right now, almost every village has at least between 10 to over 30 youths abusing drugs.
Now, colleagues, I'm not seeing anyone here who is against establishment. We need them. But now, do we need to say, Minister, you must? No, funds are out, Honorable Boss. If funds are out, the minister will establish.
Thank you very much, Right Honorable Chair. I think that is better drafting, that you allow some discretionary powers. And that what you are falling short of saying is that as long as funds permit. And here, the law being proposed is that the minister may establish, designate, or approve. So it's not just a question of establishing, it's more wider. And when you put shall, then you're killing the intent of this law. When you put it as a mandate, we believe that the Minister of Health will be the minister who cares about Ugandans and will take her work very seriously. So the discretion will not be abused. But this is to give her the latitude, or him the latitude. Next time could be Honorable Jonathan, who is the Minister of Health. Give her or him the latitude to perform her duties. But also in drafting, it is only proper that the word may is adopted internationally.
Thank you. Honorable Taylor, you wanted to add on?
Thank you, Honorable Chair. Well, as I entirely agree with Honorable both, may we suggest, because of the gravity of the problem, to talk about regional centers as opposed to generalizing that he may set up centers. If we refer to regionally, then we'll be able to spread them widely and then also reach out to different individuals who are having the challenge.
No, Honorable, in legislation, you don't do that, okay? In legislation, that is a policy matter now. It becomes a policy matter which depends on availability of funds and all that. I put a question that clause 53 be amended as proposed. Those in favor say aye to the contrary nay. The ayes have it.
Clause 53 as amended.
I put a question that clause 53 as amended be stand as part of the bill. Those in favor say aye to the contrary nay. The ayes have it. Now on this 53, the one for health was reinforcing the one for defense, and we agreed it will be cleaned up at the final stage. Yeah.
Clause 54.
Chair. Right Honorable Chair, clause 54 deals with rehabilitation fund. Clause 54 is amended by inserting in subsection 2 the following: money provided by medical insurance. Justification: some clients under treatment and rehabilitation centers have insurance policy covering such conditions, and therefore in case of admission, the insurer shall pay that money to the rehabilitation fund to take care of the patient. I submit.
Chair, Committee on Health.
Thank you, Chair. The Committee of Health proposes a new amendment that Clause 54 should be entirely deleted. The justification is that it's a policy of government through the Public Finance Management Act to restrict the establishment of funds.
Now, this addresses the concern which had been raised by Honorable Kanya earlier on, referring to the PFMI. Is it different in any way or another? If it's not different, we move. Well, so I put a question that Clause 54 be deleted. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 55.
Now, Honorable colleagues, then it would have to delete Clause 55, Clause 56, Clause 50. Yeah, those three, isn't it? Yeah, so. Honorable colleagues, I put a question that Clause 55 be deleted. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 56.
I put a question that Clause 56 be deleted. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 57.
Chair. I put a question that Clause 57 stand as part of the bill. Those in favor say aye, and to the contrary nay. Oh, Chair, yes, you had an issue? Okay. I didn't know you have many troops here, Chair. Yeah, sure.
Thank you, Chair. This new amendment, by substituting the committee's proposal is a new amendment by substituting the Rehabilitation of Narcotic Advisory Committee for the Rehabilitation of Narcotic Addicts with the following: the Uganda Mental Health Advisory Board. Mr. Chair, the Uganda Mental Health Advisory Board is established under the Mental Health Act 2018 and shall advise the minister responsible for health on matters that the minister may refer to the Uganda Mental Health Advisory Board relating to the administration of the centers and the treatment and rehabilitation of persons with substance use disorder. The justification is the Mental Health Act defines mental illness as a diagnosis of mental health conditions in terms of accepted diagnostic criteria made by a mental health practitioner or medical practitioner authorized to make such diagnosis. And one of the examples of mental health conditions includes addictive behavior due to alcohol, stroke, substance abuse, among others. Therefore, since substance use disorder is categorized as one of the conditions that fall under the Mental Health Act, then it is best if monitoring of the treatment and rehabilitation centers is given to an already existing board doing the same work as the advisory committee for the rehabilitation of addicts that the bill seeks to establish. Thank you.
Yes.
Chair, would it be improper if we added Minister of Health and Minister of Education? Because most of these substances, young people begin it at school, and some of us who are in this social sector face a big challenge. If you have the Minister of Education that is not informed, would it be a problem if we added Minister of Health and Minister of Education?
Honorable, because someone will also say add Minister for Youth, because the youth are the most affected. So that, yeah. Honorable Minister.
I agree to the proposed amendments by the Chair.
Put a question that Clause 57 be amended as proposed. Those in favor say aye, and the contrary nay. The ayes have it.
Clause 57 as amended.
I put a question that Clause 57 as amended stands as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 58.
Honorable Yume.
The committee proposes that Clause 58 be deleted, and the justification is that the functions have been incorporated under Clause 57. Thank you.
Honourable Minister.
Agreed, Right Honourable Speaker.
Honourable colleagues, I put a question that Clause 58 be deleted as proposed. Those in favour say aye, and to the contrary nay. Ayes have it.
Clause 59.
Chair, Committee on Defence. Oh, you still have proposal for a new clause? Okay.
Mr. Chairman, the committee proposes insertion of a new clause immediately after Clause 58 as follows: treatment, rehabilitation, and admission of persons with substance abuse disorder. Subclause 1, a medical practitioner, mental health practitioner, parent, guardian, or concerned person may refer a person with substance use disorder to a health unit or treatment and rehabilitation center for treatment, care, or rehabilitation. Subclause 2, a person with substance use disorder who has attained the apparent age of 18 years may submit voluntarily to a health unit or treatment and rehabilitation center for voluntary treatment, care, or rehabilitation in accordance with the Mental Health Act 2018. Subclause 3, a person shall not be provided with treatment, care, or rehabilitation or be admitted at a health unit or treatment and rehabilitation center except in accordance with Part 3 of the Mental Health Act 2018. The justification is to provide the procedures for admission and treatment of persons with substance use disorder in compliance with the Mental Health Act. Thank you.
No, Minister.
Additional amendments allowed.
Colleagues, where we are complying with another law, usually don't have much in terms of.
Chair, it's on the edge. When the chair talks of 18, that was then when we believed that it's only adults who would participate in the usage of drugs. But, Right Honourable Chair, we have kids as young as 10 years, 11, 12, 13. So when we state the age 18, where are the young ones going to go? Because these rehabilitation centers will not admit. It's happening currently.
Honourable, ahead we are providing for children. If you read the bill the way it is.
Thank you.
Okay, they had to be separated. Honourable colleagues, I put a question that a new clause be inserted as proposed. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 59.
Chair.
Right Honourable Chair, Clause 59 deals with committal of persons to centres. Clause 59 is amended, A, by substituting in the head note with the words committal of persons to facility for treatment and rehabilitation. B, in subclause 1, by deleting the words and that he or she is in possession of a narcotic drug or psychotropic substance only for his or her personal consumption. C, by inserting immediately after subclause 1 the following: notwithstanding subsection 1, a medical practitioner or a parent or guardian of a person who is satisfied that that person is addicted to a narcotic drug or psychotropic substance may refer the person to a facility for treatment and rehabilitation of persons with substance use disorder. A court, parent, or guardian shall not order or refer a person to a facility for treatment and rehabilitation of persons without the medical opinion of a medical practitioner confirming that a person is addicted to a narcotic drug or psychotropic substance. D, by inserting immediately after subclause 2B6 the following agriculture. By inserting immediately after subclause 2F the following word: a consultant in psychiatry and mental health. Justification for this is to delete redundant words and ensure that only addicts are referred for rehabilitation. 2, to enable a medical practitioner, parent, or guardian to refer a person addicted to narcotic drug or psychotropic substance for treatment and rehabilitation. I submit.
Thank you. Honorable Yume.
The committee proposes an amendment as follows to clause 59. Subclause A, by substituting for the head note the following.
That's an amendment to the report.
Yes.
The proposed amendment.
Yes, Mr. Chair.
Okay.
Treatment, care, and rehabilitation of a convicted person with substance use disorder. Subclause B, by substituting for subclause 1 the following. A court which convicts any person for an offense under this act may, if it is satisfied that the person has substance use disorder, order that a part of the period of imprisonment imposed on him or her be spent in a treatment and rehabilitation center specified by the court. Subclause C, in subclause 3, by substituting for the words an addict, the word has substance use disorder. The justification is for consistency in use of the phrase substance use disorder rather than the word addict. To clarify on the nature of center to refer a convicted person with substance use disorder. Thank you.
Thank you. Honorable Chair, Defense. Yes, I will allow them.
Right, Honorable Chair, you know these are improvements that we agreed upon under harmonization. I absolutely have no problem with it.
Thank you. Honorable Cecilia Ogwa.
Yeah, clarification, Chair. Chair, I heard the Committee of Health suggesting that the person cannot be committed to the center unless they get approval from the medical practitioner. Now, we are aware that many of these substance abusers are very aggressive and violent. Now, in a situation where a parent or a teacher is to commit the offender to some rehabilitation center, how do you handle such a situation when they become violent or unable to be handled by either the parents or the teachers? I wish to be guided on that.
Thank you. Can I first get a clarification on that?
Thank you very much, Mr. Chair. In the clause that we inserted, if I may read, treatment, rehabilitation, and admission of persons with substance use disorder. Subclause 1 is a medical practitioner, a mental health practitioner, a parent, guardian, or concerned person may refer a person with substance use disorder to a health unit or treatment and rehabilitation center for treatment, care, or rehabilitation.
Thank you. Honorable Jonathan Odu.
Chair, my concern is that the amendments appear to be good, but doesn't address the spirit. This is specifically for convicts. The original intention here is for convicts. Now, if we open it up to bring others, I think it may cloud the intention of this specific. So while I agree with him that with the subheading can change to be treatment of convicts, because this is about court and the Attorney General applying. If you look at the original text, if you admit it and under this, it may cloud. Maybe we can make it as a new, so that it addresses medical, other people who can be able to refer them.
Honorable Yume.
Mr. Chairman, that is a new insertion, but the one of convicts is taken care of in clause 59, which is commit of persons to centers.
Because the new insertion covered the general population. Okay? That was the new insertion which he read clarifying for Honorable Cecilia Ogwa. But now this one is for convicts. So, yeah, we're on 59. So, Honorable Jonathan Odu, you still see gaps? We are opening up beyond convicts? Honorable Sewungu?
And fortunately, Landy Friend is there, Honorable Minister for State for Defense. you must be very careful when you address, and the Minister of State, of course, is from Masaka, by the way. But you must be very careful. When you go to the penal code, the issue of insanity and state of mind is very key, where someone can be acquitted. Now, with this law, as Honorable Dul is saying, we must be very careful when we take consideration of the Honorable Dr. Ayume, where he brings that treatment and the sickness, where he has to be referred to hospital. Because you are looking at a crime of selling of these unwanted materials, marijuana and others. But now you are bringing in treatment. And yet the penal code is very clear on the state of mind.
But Honorable, here it is court. It is court.
It will
court which court has looked at all these other laws. Yeah. Okay.
Thank you, Mr. Chairman.
Yeah, it's court. Honorable Lola.
Thank you, Mr. Speaker. I want to be guided on slightly the same issue that Honorable Seung is raising, because I know that most of the addicts or people who have mental illness cannot stand trial. But I also know that there is a law on the minister's order, especially in the criminal justice system, that if someone is convicted of an offense, but they have mental illness or they are insane, as the penal code calls them, they are sent to jail pending the minister's order. So I am looking for guidance regarding this specific provision on 59, and then for a person with mental illness who has been convicted of an offense and has to wait for the minister's order. I want a bit of clarity on those two laws, because I'm a little confused.
Honorable, we are dealing with convicts of substance abuse, not mental illness. Okay?
Right, Honorable Speaker. There are people who are on drugs, and I'm saying this because these people belong under my constituency, under the Persons with Disabilities Act, people with mental illness, and I know for a fact that most people who are addicts also have a form of mental illness. So this is where I'm coming from.
You see, this has been determined by court. Whichever way, whatever you do, it is court which has clearly determined. And a court which convicts any person for an offense under this act, okay? Yeah, it has seen you committing, it has concluded that you committed an offense under this act, and therefore you should be taken for treatment. It's court. It's not the state, it's not who, it's court. And it may, or it may not. Very simple. Honorable Doctor, you may, as a doctor, I wanted to.
Mr. Chairman, we had made a provision for a new insertion, and I think the honorable member's concerns are captured in the new insertion that I will read. Thank you.
Colleagues, I put a question that clause 59 be amended as proposed. Those in favor say aye, and the contrary nay. The ayes have it.
Clause 59 as amended.
I put a question that clause 59 as amended stands as part of the bill. Those in favor say aye, and the contrary nay. The ayes have it.
Clause 60.
No, there is a new insertion. Yeah. Proposed a new insertion.
Thank you, Mr. Chairman. The committee proposes a new insertion. Insert a new clause immediately after clause 59 as follows. Treatment of a prisoner or a child in a remand home with substance use disorder. Subclause 1, where it appears that the officer in charge of a prison, through observation or from information provided, that a prisoner or a child in a remand home may have substance use disorder, the officer in charge of a prison shall cause an examination of the mental health status of the prisoner or child to be carried out in accordance with the Mental Health Act. Subclause 2, where as a result of the examination carried out under subsection 1, the psychiatrist, medical practitioner, or mental health practitioner determines that the nature of substance use disorder of the prisoner or child in a remand home can only be treated in a treatment and rehabilitation center, the officer in charge of the prison shall apply to court for an order to cause the prisoner or child in a remand home to be transferred to a treatment and rehabilitation center. Subclause 3, where as a result of the examination carried out under subsection 1, it is determined that the prisoner or child in a remand home can be treated in the prison or remand home, the officer in charge shall take the necessary steps to ensure that the required treatment, care, or rehabilitation is provided to that prisoner or child in a remand home. Subclause 4, a person who makes an assessment, treats, cares, rehabilitates, or carries out any process on a prisoner or child in a remand home with substance use disorder shall make the assessment, treatment, care, and rehabilitation or any other process in accordance with Part 5 of the Mental Health Act 2018. The justification is to provide for the treatment, care, and rehabilitation of prisoners and children in remand homes who have substance use disorder. Thank you.
Honorable Minister.
New insertion allowed.
Thank you. Honorable colleagues, I put a question that a new clause be inserted as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 60.
Honorable colleagues, I put a question that clause 60 stand as part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 61.
Honorable colleagues, I put the question that clause 61 stands as part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 62.
I put the question that clause 62 stands as part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
63.
I put the question that clause 63 stands as part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 64.
I put the question that clause 64 stands as part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 65.
I put the question that clause 65 stands as part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 66.
I put the question that clause 66 stands as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 67.
Chair, Committee on Health.
Thank you, Mr. Chair. The committee proposes the following amendments on clause 67, which reads, government obligation to take measures for preventing drug abuse. Subclause A in the head note, by substituting the word drug abuse, the words narcotic drugs and psychotropic substance abuse, and thereafter wherever the word appears in the bill. Subclause B, in subclause 1, by substituting for the words abuse of narcotic drugs and psychotropic substances, the words narcotic drugs and psychotropic substance abuse, and thereafter wherever the word appears in the bill. The justification is A, the word drug abuse is derogatory, stigmatizing, and no longer used in modern medical literature. B, the use of the word drug causes confusion. Thank you.
Honourable Minister.
The amendments proposed are allowed.
Thank you, Honourable colleagues. I put a question that clause 67 be amended as proposed. Those in favor say aye, and the contrary nay. Ayes have it.
Clause 67 as amended.
I put a question that clause 67 as amended stands as part of the bill. Those in favor say aye, and the contrary nay. Ayes have it.
Clause 68.
Chair, defense.
Right, Honorable Chair. Clause 68, the establishment of National Coordination Committee for Drug Control. Clause 68 is amended, substituting for Clause 1 the following. The establishment of the committee to be known as the National Coordination Committee for Control of Narcotic Drugs, Psychotropic Substances, and Other Substances. B, in subclause 2, in paragraph A, by inserting immediately after the word ministry, words of internal affairs. 2, by inserting immediately after paragraph F, the following, a consultant in psychiatry and mental health. A senior agricultural research officer. Justification for this: a committee established under this clause is for purposes of controlling the use of narcotic drugs, psychotropic substances, and other substances. 2, the ministry coordinating the committee is the Ministry of Internal Affairs. 3, there is a need to include in the committee a person knowledgeable about psychoactive issues and research about agricultural products produced from the prohibited trees. I submit.
Dr. Yume.
Thank you, Mr. Chair. We agree with the report on clause 68 by the committee, but would propose the following amendments. Clause 68 is amended by substituting for subclause 1 the following. There is established a committee to be known as the National Coordination Committee for the Control of Narcotic Drugs and Psychotropic Substances. Subclause B, in subclause 2, in paragraph 1A, by inserting immediately after the word ministry the words of health. 2, in paragraph B, by deleting subparagraph 1, and in subparagraph 2 by substituting for the word health the word internal affairs. 3, by inserting immediately after paragraph B, before the following subparagraph, agriculture. 4, by inserting immediately after paragraph B the following, the Solicitor General. 5, by substituting for paragraph E the following, Secretary to the National Drug Authority. 6, by inserting immediately after paragraph F the following, a consultant in psychiatry and mental health appointed by the minister responsible for health. The justification, A, to restrict the role of the committee to narcotic drugs and psychotropic substances. B, to align the functions of Ministry of Health in regulating control of drugs in Uganda in line with the NDA Act. C, the deletion of Ministry of Justice is to give government legal representation on the committee. D, to provide for the right title as is provided under Section 54, subsection 2 of the National Drug Policy and Authority Act.
Honourable Minister for Internal Affairs, we've heard both. Health is improving on what internal affairs?
The improvements by the chair committee health are allowed.
Thank you. I'm going to Honorable Cicero Gwar, Honorable Songa, Honorable Nanda.
Chair, I appreciate the specification given by the Committee of Health. However, drawing from the experience we had of COVID-19, I realized that drug abuse has become rural to the extent that the villagers are very much involved in it. And I do not know whether in this composition we could get the LC1s or the local government team to assist in ensuring that the committee is well versed with what goes on in the rural area. Because if we put them hanging at the national level, we may not be able to appreciate the gravity of the matter at the rural level. So I'm just seeking clarification on that.
Sure. I think that would be an operational matter. In the implementation stages, they can include GSOs, religious leaders, counselors in the areas. Okay? Yeah. I had Honorable Songa.
Yeah, thank you. I have a small comment, especially the chair defense. The last two words you mentioned was prohibited trees. Not all these narcotics will be trees. Can we say plants? Thank you.
Mr. Chairman.
As if Chairman Committee on Health had addressed that. Yeah? Yes. The improvement by health had addressed that. Honorable Nandara.
Mr. Chairman, according to the Chair of Health, is changing the chairperson from Ministry of Health, Ministry of Internal Affairs to Ministry PS of Health. I wanted to ask the minister if this is agreeable to you, because
Honorable Nandala, yes, yesterday we held a long meeting to go through, because some of these things needed someone neutral, where the ministers, both ministers were in, Minister for Health, Minister for, and after they found the bigger role is with the Minister of Health, and that's how they agreed on Minister of Health. Yeah.
So, Mr. Chairman, now if that's agreed, according to the additions which the committee was adding a senior agriculture research officer, but in the wisdom of the chair of health is saying we put PS, Ministry of Agriculture. Will this also still stand? Because now in agriculture we have now brought the PS himself or herself instead of the agriculture research officer. Two, Mr. Chairman, the other point which I wanted.
Honorable, can you propose?
Now I want to propose that now, since we have included the PS of agriculture, we delete a senior agriculture research officer. Now, then I want to
let him conclude. Let him conclude.
Yes, Mr. Chairman. The other issue I want to raise, these are PSs only. If they are not there, what happens? So wouldn't it be better to say the PS or their representative? Because if that doesn't happen, there will be no meeting. Because here it says the PS, it means it's the PS to be in the meeting.
Thank you. Now, you know, when we were in that meeting, someone gave an example. I'm sorry for, I shouldn't be putting such issues directly, but someone gave an example that there is a ministry which is being investigated, and the sweeper had been appointed on the procurement committee. Okay? So someone said, and the sweeper had, so for such a sensitive, I remember they said, for such a sensitive committee, that's why they never wanted to take risks. Maybe if you say the qualifications of the person who can be appointed. Honorable Milton Muma.
Yeah, thank you very much, Mr. Chair. Mr. Chairman, in line with the Honorable Nandala's submission, from the experience of the former REA board, I remember there was an audit report here that the board had never failed to meet because of the busy schedules of the permanent secretaries. Getting quorum had become a challenge. So transacting business couldn't go, so move on. So I would think if we inserted here after Roman 5 that any officer designated by the PS, instead of keeping these busy officers with more work,
okay,
I think it...
Don't you think, our colleagues, that address the concern of Honorable Nanda and Milton and Honorable Milton Muma, and the concern of the person who made that statement? If we said, for example, his or her representative not below the rank of a commissioner, for example, because they have very many commissioners in the ministries. Honorable Minister, would that?
I think Commissioner is fair enough, Right Honourable Speaker.
Yeah, colleagues, really, let's move. I put a question that you've already proposed what you proposed, Honourable.
Mr. Chairman, for the record, I wanted to correct something that the proposals by the Committee of Health are to substitute what was proposed by the Committee of Defense and Internal Affairs.
So does it cover all, Chair, Defense and Internal Affairs? Are you satisfied?
Right Honourable Chair, what we agreed in the harmonization, where they are improving on our own, we accept. We are not in disagreement. Where they are bringing anything new, we also accept. It's an improvement. But where they are silent, then ours is accepted, because this is the main report. Yes.
I put a question that clause 68B amended as proposed. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 68 as amended.
I put a question that clause 68 as amended stands as part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 69.
Chair.
Thank you, Right Honorable Chair. Clause 69 addresses the functions of the committee. Clause 69 is amended in subclause 1 by substituting for the words drug abuse and trafficking the words narcotic drugs and psychotropic substances. Justification: the mandate of the committee is limited to the control of narcotic drugs, psychotropic substances, and other related substances, not all drugs. I submit.
Honorable, you may.
Thank you, Mr. Chair. The committee proposes the following amendments.
Is it an improvement or it's a replacement of the...
we are improving what was submitted by the Committee of Defense and Internal Affairs.
Okay.
Subclause A, in paragraph A, by substituting the word drug control, the words the control of narcotic drugs and psychotropic substances. Subclause B, by substituting for paragraph C the following: updating and adapting laws and regulations to control narcotic drugs and psychotropic substances. C, in paragraph D, by substituting for the word professors the word professionals. D, in paragraph F, by substituting for the word drug addicts the word persons with substance use disorder. Subclause E, in paragraph G, by substituting the word drug addiction the word substance use disorder. The justification is: A, the mandate of the committee is limited to the control of narcotic drugs and psychotropic substances, but not all drugs. B, to avoid ambiguity and prevent a situation where there is a dual mandate in law, since the general control of drugs is the mandate of the National Drug Authority. Thank you.
Thank you. Honourable Minister.
Improvements by Chair Health allowed.
Honourable Chair, Committee on Internal Affairs.
I agree to the improvements.
Chiwoga.
Chair, on the naming of the committee, let's come up with the name of the committee.
Honourable, are you recommitting clause 68? We've already finished it. We're on 69,
69.
We're on functions.
When you look at the naming of the committee,
the committee is named 68,
68,
not 69.
I didn't.
So we're on function. Yeah. Honourable colleagues, I put a question that clause 69 be amended as proposed. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 69 as amended.
I put a question that clause 69 as amended stands as part of the bill. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 70.
Yeah, new clause before clause 70.
Insert a new clause immediately after clause 69 as follows: remuneration of committee. The chairperson and the members of the committee shall be paid such remuneration as the minister responsible for health may, in consultation with the minister responsible for finance and minister responsible for internal affairs, specify in the instruments of appointment.
Honourable Minister.
New insertion accepted.
Honourable colleagues, I put a question that a new clause be inserted. Those in favour say aye, and the contrary nay. The ayes have it.
Clause 70.
Now, honourable colleagues, before we go to clause 70, I've just checked on clause 69. 2C. Okay? So I think, Honourable Minister, you will need to recommit this clause. Because here they cannot update on update and adopting drug control laws and regulations. The committee can only propose. Okay? It cannot be the one to update. So, but you study it, because I'm just seeing it here. You study and you see if it needs recommittal, and you can take note of that. You do it in a clean way. The problem now, you see now we are interpreting. Yeah. Clause 70, Chair, Committee on Health. Oh, Chair, Committee on Defense, you don't have an issue there. It's Committee on Health.
Clause 70, reports of committee to be laid before Parliament. Clause 70 is amended by substituting for the word committee the words minister responsible for health. The justification is the committee shall be supervised by the minister responsible for health, and since it has no capacity to lay the reports before Parliament, it should be the responsibility of the minister to do so.
Thank you. Honourable Minister.
Makes absolute sense. Allowed.
Honourable colleagues, I put a question that clause 70 be amended as proposed. Those in favour say aye, and the contrary nay. The ayes have it.
Clause 70 as amended.
Honourable Chair for Health. Oh, sorry. Honourable colleagues, I put a question that clause 70 as amended stands as part of the bill. Those in favour say aye, and the contrary nay. The ayes have it.
Clause 71.
Chair, Committee for Health.
Thank you, Chair. Clause 71, establishment of the Secretariat. The committee proposes deletion of clause 54. Of clause 70, of clause 71. The justification is to avoid duplicating functions with existing entities of government and to align the bill with the government policy of rationalization of government ministries, departments, and agencies.
Honourable Minister.
Agreed.
Honourable Jonathan.
Chair, when you look at the committee and the functions that we have already given to them, that is from 69 to A up to J, the committee cannot function without technical support. And if we delete the establishment of the Secretariat, it may cripple the work of this committee. So therefore, if we are uncomfortable with the extra cost, we may then go for designation, because within the ministries they have public officers who can be designated to be, or one of the departments or one of the commissioners is then designated as the Secretariat, but there must be a Secretariat to support them.
Don't you think this can be an operational matter? You know, or do we need to legislate over it? That there must be a Secretariat? And
yeah, then you have to give the powers to that committee to do that, because otherwise you are bringing different permanent secretaries and the rest. There will be a clash on who should actually be hosting. And so we give the committee that the committee can establish a secretariat.
But they have
for
a chair already. Yeah. Yeah. Honorable Kanya.
I want to beseech Honorable Jonathan that Minister can handle this through a regulation or statutory instrument, something, so that it is more flexible. And that regulation or statutory instrument will be laid here in case we are uncomfortable. We can then improve. Thank you.
Mogore.
Yeah. Thank you, Right Honourable Speaker. In that particular regard, then it would be, whereas the minister has the right to come up with an instrument, but in particular laws, now like with this specificality, it would be prudent for us to put even here that the minister shall come up with a regulation in this particular section.
Of course, we have regulation they are required under the bill. The bill, the law will be read in whole.
Chair, I had reservations when I looked at the functions which had earlier passed, 29 and 69, 68. I was comforted. I was with him. I was comforted when I read 71. I said, okay, if 71 addresses, because, Chair, I think this committee did not benchmark. Our previous committee benchmarked extensively when we were doing the other previous law. And we went to Kenya and interacted with the coordinator of a similar body. And he gave us a full report of what he does and the extent he was fighting drug. I don't think this committee constituted here without this secretariat will effectively be of any consequence in this fight. Because it goes even beyond what we know. I've seen here sensitization, and you need hands-on, and you need to buttress this body to fight this vice effectively. So in my humble view, Chair, and I want to beseech the ministers, they could have harmonized. And even another country benchmarked had this coordinator. So I was looking at 71 as a mean body that would carry out these aggressive functions and do this kind of big job in this sector. I would like to beseech to go back to this original idea.
Honorable Nandara.
Mr. Chairman, from what I'm saying, we have not established where the secretariat will be. Where would the committee be?
Health, Minister of Health.
So if it is under the Minister of Health,
yeah,
then we can say establishment of a secretariat in the Ministry of Health, and we leave it to them, because they can get one of the departments to manage and be in charge. So I think if the moment you bring a secretariat here, you are trying to also create what we call a vote. You are trying to create more staff, but yet we are saying for drug control, URA is concerned, police is concerned, everybody is concerned. It's a combined sector. So we could only have to say the Minister of Health shall host the secretariat for purposes.
Colleagues, the government has leeway, the executive has leeway. They are going to implement. Honorable Obosbo.
Thank you, Honorable, Right Honorable Chair. And I had not seen Honorable Bafabi and Andala. I must congratulate you we are praying for you very, very fairly. You know what I mean. Yeah. We shall stand by you as the faithful. We shall defend you for fair hearing. But the matter here, we are introducing, the bill is actually trying to introduce something, secretariat. It is convenient to mention it. But government is undergoing many things now, rationalization. And I believe that the chairperson of health was alive to this, that the general administration of ministries, the reorganizing, some of these things that a secretariat would do would be put under a particular commissioner also. And whereas secretariat sounds well, you know that there is a ministry which is under STI, which is a secretariat. So I think the delineation I would go with the honorable chair for
thank you.
And the Minister of Internal Affairs.
Thank you. Honorable colleagues, I put a question that clause 71 be deleted as proposed. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 72.
Honorable Chair.
Right, Honorable Chair, Clause 72 concerns the establishment of a national fund for drug control.
No, he's presenting a committee report.
It's procedure.
So he must.
Yeah. Actually. Clause 72 is amended in subclause 1 by substituting for the word drug control and words control of narcotic drugs and psychotropic substances. Justification: the mandate of the committee is limited to the control of narcotic drugs, psychotropic substances, and other related material substances, not all drugs. I submit.
Chair, Committee on Health.
Thank you, Chair. The proposal by the Committee of Health seeks to override the proposal of the Committee of Defense and Internal Affairs by deletion of Clause 72.
Honourable Minister.
The justification is it's a policy of government through the Public Finance Management Act to restrict the establishment of funds.
Honourable Minister.
Deletion allowed.
Honourable colleagues, I put a question that Clause 72 be deleted as proposed. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 73.
The same it goes with it. Honourable colleagues, I put a question that Clause 73 be deleted. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 74.
Honourable colleagues, I put a question that Clause 74 stands as part of the bill. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 75.
I put a question that Clause 75 stands as part of the bill. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 76.
I put a question that Clause 76 stands as part of the bill. Those in favour say aye, and to the contrary nay. Ayes have it.
Clause 77.
Chair.
Right Honourable Chair, Clause 77 is power to question and request production of documents. Clause 77 is amended by substituting for words police officer wherever it appears in that clause with the words police officer at the rank of inspector or a person authorized. Justification: police officer at the rank of inspector is an authorized officer who can search at any time as provided by the Police Act, and the person authorized is the person officially recognized by this Act. I submit.
Honourable Minister.
The amendment is allowed.
Honourable colleagues, I put a question that Clause 77 be amended as proposed. Those in favour say aye, and to the contrary nay. The ayes have it.
Clause 77 as amended.
I put a question that Clause 77 as amended stands part of the bill. Those in favour say aye, and to the contrary nay. Ayes have it.
Clause 78.
I put a question that Clause 78 stands part of the bill. Those in favour say aye, and to the contrary nay. Ayes have it.
Clause 79.
Chair.
Right Honourable Chair, Clause 79 concerns inspection. Clause 79 is amended by substituting for the words any police officer wherever it appears in that clause with words police officer at the rank of inspector. Justification: police officer at the rank of inspector is an authorized officer who can search at any time as provided by the Police Act. I submit.
Honourable Chair, Committee on Health.
Thank you very much, Chair. The Committee of Health agrees with the position but wants to make a slight amendment. Clause 79 is amended by substituting for the phrase Executive Secretary to the National Drug Authority the phrase Secretary to the National Drug Authority. The justification is to provide for the right nomenclature under Section 51, subsection 2 of the National Drug Policy and Authority Act. Thank you.
Honourable Minister.
The amendments by both committees are allowed.
Thank you. Honourable colleagues, I put a question that Clause 79 be amended as proposed. Those in favour say aye, and the contrary nay. The ayes have it.
Clause 79 as amended.
I put a question that Clause 79 as amended stands part of the bill. Those in favour say aye, and the contrary nay. Ayes have it.
Clause 80.
Chair.
Right Honourable Chair, Clause 80 concerns power to search persons and vehicles. Clause 80 is amended by substituting the words any police officer with the words police officer with a search warrant. Justification: to clarify who should conduct a search to a person, vehicle, premises as provided in clause 81(1). I submit.
Honourable Minister.
Amendment allowed.
Okay. Honourable Nandara.
Mr. Chairman, if we are looking at a search warrant for a motor vehicle, for a ship which is running, if it, let us give it an example. On a weekend, courts are not there, search warrants are only issued by court. So, Mr. Chairman, wouldn't it be having some exceptions to search? Because if you are looking for a warrant to go and search a car which is running or which is, anything can happen.
Honourable Minister, I wanted first to respond to that. Or is it related?
Yes.
Okay. Isaac.
All along we've been using the word police in the rank of inspector, allowing them to actually do the search. But in this case, the Committee of Internal Affairs seems to have omitted that and gave it that police, with any policeman with a warrant.
On search. This is searching. Okay? Yeah, this is on searching. Yes, Honourable Taylor.
Chair, on the use of the word inspector of police, I think we are omitting something very pertinent for someone of or above the rank of inspector of police, because it allows even someone more superior to do the inspection. Thank you.
Honourable Minister.
The inspector rank is a threshold of seniority. It can be that or above. But for Right Honourable Speaker, for the matter of such warrant, I tend to be persuaded by the Honourable Nandala that we need a qualification. Where it can't be got, you put a proviso. Can it be acquired ex post facto after the search?
No, 88 is power to arrest without warrant. Okay. Yeah. So, what would be, Honourable Taylor, you wanted to propose?
Yes, Chair, most of the drug-related offences are usually strict liability offences. And this is done because of the circumstances under which the offences are committed. So waiting for a search warrant, sometimes we are dealing with very smart individuals who engage themselves in these cartels. I would suggest that we drop the whole idea of a search warrant, because a drug-related offense is a strict liability offense where you need to prove your innocence as opposed to the usual presumption of innocence.
Because you see, honourable colleagues, an office is on duty at 3 a.m. Okay? And a car comes, people blaring music and all that, and he feels some people are smelling some drugs, and he feels I should search whether these people have drugs in their car. Would he need it first go and get a search warrant? Okay. There he would be having the power to search without a warrant. Okay. Honourable Mugore?
Chair, I suppose why they were bringing this was to presuppose that somebody could bring in drugs in your house or in your car, but after having provided that there should be a senior officer or at least an inspector, I think the issue of having a warrant could be dropped, and we maintain the seniority of an officer going to search.
Under 8, Honourable Jonathan.
Chair, I was also quite surprised that the minister conceded to that amendment. Already by practice, the police have been stopping us using those powers, whether traffic or what, they look at your car, it's the same. It's the same. I don't know about Palmer. So I would propose that we retain, because for premises, it's scattered under 81, because they are the power of entry. But for this purpose, I think 80 can be retained as it is, so that it doesn't curtail the effort.
Chair? Yes, Honorable Cecilia Ogwa.
Chair, I want to be assured, because if the police, as Jonathan explained, can stop me and search my car, but knowing that drug has become a negative, has had negative social impact. For some of us who are politicians, we can be targeted. Somebody just to malign your name, they stop you somewhere, they search you and so on. They may not find drug, but it is all over their papers that you were stopped and searched in case you had drugs. So can there be a clause that can insulate political figures? Because we can be targeted, particularly with the opposition, especially me.
But Honorable colleagues, we had a clause that has to do with malicious. You know, you remember yesterday we handled that clause extensively. Okay? So, and any officer who commits such an offense also is there for 10 years. We agreed on 10. We raised it to 10 years. So also that officer knows they have an obligation. And Honorable Chair, would you want to?
Right Honorable Chair, having listened to the convincing arguments from the August House and knowing that we should not restrict the work of police as they conduct their usual business, I agree that we drop the issue of a search warrant. And
we retain.
We retain, absolutely. We retain.
Honorable colleagues, I put a question that clause 8 stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 81.
Chair.
Right Honorable Chair, clause 81 is power to such premises. Clause 81 is amended in subclause 3 by deleting paragraph A and B. Justification, consequential amendments having deleted clause 27 and 37. I submit.
Thank you. Honorable colleagues, I put a question that clause 81 be amended as proposed. Those in favor say aye, and the contrary nay. The ayes have it.
Clause 81 as amended.
Put a question that clause 21 as amended stands part of the bill. Those in favor? Oh, sorry, colleagues. I put a question that clause 81 as amended stands part of the bill. Those in favor say aye, and the contrary nay. The ayes have it.
Clause 82.
I put the question that clause 82 stands part of the bill. Those in favor say aye, and the contrary nay. The ayes have it.
Clause 83.
I put a question that clause 83 stands part of the bill. Those in favor say aye, and the contrary nay.
Aye.
The ayes have it.
Clause 84.
I put a question that clause 84 stands part of the bill. Those in favor say. Honorable Nambeshe, you see, colleagues, I turn around. If I don't see any one of you, then I do. So, Honorable Nambeshe.
Mr. Chairman, the monitoring of the mail or consignment by the police, this clause gives extensive powers, discretionary powers to the police, and it can easily be abused, Mr. Speaker. I would propose that he has powers to open, seize, and even detain. But I would propose that it should be, such consignment should be opened in the presence of the interested parties, say the recipient and the sender, if possible, but also before an impartial, competent judicial officer.
Honorable Guzuri, then Honorable Isaac.
Chair, the function of easily identifying if there may be drugs in a parcel or courier item could easily be executed by the postal officials. I would have loved if we
place some responsibility with them, and maybe they notify the police. Otherwise, to say the police will be monitoring, I don't know how practically possible this is going to be. Do we intend to station police officers in checking this? If we really want to routinely achieve this, we should give some role to the postal officials and place responsibility with them.
Honorable
Chair, actually, some of this are already taking place. In many countries, I believe even in Uganda, all, especially international mail coming into the country, are subject to security check as it takes place through the border. And that actually includes even some security personnel and airport authorities already. So I do not see this changing much as it is within the bill.
Honorable Bosobos.
He literally spoke my mind, but I also want to comfort Honorable Bishop Nambeshe. He used to be a bishop in the last parliament. That who would abuse your mail? Actually, this is formalizing it. That you no longer get those mails. That why are you scared that you do get mails? So this is an international practice. You can even Google world over. It is practice. I'm even surprised that we're just legislating now.
So,
we should have let it pass.
Colleagues, you see, it's qualified, has reasonable grounds. It's not just coming and it might be a racket they've suspected and they've come and they tried it for up. Okay? Honorable Mushemeza?
Mr. Chairman, this is a very good provision because it even provides for dealing with digital maneuvers. And it also provides for record by any means. We are dealing with very sophisticated people. Some will be armed, others will be using sophisticated digital mechanisms. I strongly propose that we maintain this provision.
Honorable Jonathan Odu.
Chair, I beg to differ and propose that we actually delete, because under 85, when you go to 85 where there is provision for seizure, if I suspect that this courier or parcel is laced with narcotic drugs and psychotropic substance, why don't I then wait and seize it in the presence of the person? If you read 85, still the police officer would be able to seize it in the presence of the person. Because you are avoiding a situation where I am not there. I am not there and I am not present. And then it is alleged that this item was in the courier meant for me, and yet you access it when I was not there in my presence. Why don't you detain it, wait for me, and then open in my presence?
Now, colleagues, you see, under the Police Act, police officers already have such powers. For any item, they can check. Section 29(1) under the Police Act. But then here also, under 85, which we are coming to, also has, is talking about sale of narcotic drugs and conveyance, and some of which have come under email and all that. So, to me, Honorable Minister, you can tell us whether what is provided for under Section 29(1) of the Police Act is not sufficient, or you felt we should also put it here. Okay. For clarity purposes.
I think, Right Honourable Speaker, it needs reinforcement by express provision in the bill.
Honourable colleagues, I put a question that clause 84 stands part of the bill. Those in favour say aye, and to the contrary nay. Aye. The ayes have it.
Clause 85.
I put the question that clause 85 stands part of the bill. Those in favour say aye, and to the contrary nay. Aye. Ayes have it.
Clause 86.
I put the question that clause 86 stands part of the bill. Those in favour say aye, and the contrary nay. Aye. Ayes have it.
Clause 87.
I put the question that clause 87 sounds part of the bill. Those in favor say aye and to the contrary nay. Aye. Ayes have it.
Clause 88.
88?
Chair, this is about seizures, and if you recall when we dealt with the restraint order, when we dealt with the forfeitures, we provided procedures of recovery. And here we don't have a procedure. Would Chair consider to have a clause, a new clause inserted, that where they have seized your property, there is also a mechanism to receive it back in case?
Honorable, you can propose. You can work. We can work around. Okay. And yes, and then. Okay. No, a new clause you can't stand over other clauses. Honorable colleagues, I put a question that clause 89, 88 stands as part of the bill. Those in favor say aye and to the contrary nay. Ayes have it.
Clause 89.
I put the question that clause 89 stands as part of the bill. Those in favor say aye and to the contrary nay. Aye. Ayes have it.
Clause 90.
Chair.
Right Honorable Chair, Clause 90 is about regulations. Clause 90, in the wisdom of the committee, they submit to the August House that Clause 90 is amended in subclause 2 by inserting the following. A, quality and quantity of narcotic drug or psychotropic substance an authorized person may be in possession with. B, the terms, conditions, and durations of the license issued under this act. C, class of drugs to be managed by the treatment and rehabilitation centers. D, personnel and standards to be observed by the treatment and rehabilitation centers. E, fees payable under this act. Justification: the minister responsible needs to have controls and measures to protect members of Ugandan society from the dangers of easy access of narcotic drugs and psychotropic substances. Right Honorable Speaker, we propose to insert a new clause, but I submit on this first, then I come up with proposal for a new clause.
Thank you. Chair, Committee on Health.
Thank you very much, Mr. Chairman. The Committee of Health allows, we're in agreement with the amendments of the committee report on subclause 2. But we propose that all the proposed paragraphs are inserted after subclause 4 because the insertions of the committee really speak to health-related functions. For example, the class of drugs to be managed by the treatment and rehabilitation is a function of the Minister of Health. Mr. Chairman, the amendments of the committee as follows. Clause 90 is amended. Subclause A, in subclause 1, by inserting immediately after the word minister, the words responsible for internal affairs. B, by deleting subclause 3. C, in paragraph 4, by deleting paragraph B. D, by inserting immediately after subclause 4 the following. Regulations may also provide for authorizing any person who is licensed or authorized and who lawfully operates a pharmacy for the retailing of poisons in accordance with the provisions of the National Drug Policy and Authority Act. A, to manufacture at the pharmacy in the ordinary course of retail business any preparation, mixture, or extract of any narcotic drugs or psychotropic substance to which this act applies. Or B, to carry on at the pharmacy the business of retailing, dispensing, or compounding any narcotic drug or psychotropic substance, subject to the powers of the minister responsible for health to withdraw the authorization in the case of a person who is convicted of an offense under this act or under the National Drug Policy and Authority Act, or who cannot, in the opinion of the minister, properly be allowed to carry on the business of manufacturing, selling, or distributing, as the case may be, of narcotic drugs or psychotropic substances. E, in subclause 6, by inserting the word responsible for internal affairs immediately after the word minister, appearing at the beginning of subclause 6. The justification is for clarity. Thank you.
Yes, Honorable Chivumbi.
Chair, I thank you for the opportunity. Chair, I propose to insert a new clause which are...
Can we first sort 91?
It's
A
90.
new- under 90?
It's under 90.
Okay, okay.
It should be gear. I don't know the word, the order. Determine the enforcement date for prohibition of growing and dealing in cat adulterers. The justification is to create a transitional period so that the Minister of Internal Affairs, because when you look at the schedule, the only new crop that is going to be banned in the schedule is only this one. The others were long before being banned. And this provision is not a new creation. It was also a provision that was in the other act that was nullified. This will give due time and power to the ministers as and when they feel they've done the necessary work, they have civic educated the affected farmers, if they so wish, just come on a day, issue an instrument, and enforce that date of prohibition. I beg the indulgence of the House.
Now, Honorable colleague, we have a farm. I know we have a farm for, is it marijuana? In Kasese. Okay? Yeah, we have one in Kasese. So it's not only cat. There are others. So if we specify one plant to be catered for under the transitional clause, I think we would have, we should make it general. We should make it general because the licensing, all of them, we gave them a chance to be licensed, to apply for a license. So it should be general, the transitional clause. Chairman, did you provide for the transitional clause in the bill? Because we have some plants which are banned but are being planted under license. So you need a transitional clause, indeed. Yes, Honorable Mushemeza. So Honorable Chivumbi,
Thank you,
the
Chair.
issue is we cover all that are already.
You see, this proposal from my friend Honorable Chivumbi may create a situation where sections of the population would want to negotiate with the government. It will create, and if you could open that window where people will come to negotiate with the government because of the law that has been passed, we are creating a very dangerous precedent. I wouldn't buy his idea of creating that room.
No, there should be transitioning. We even have
Yes, information. I was saying we should not create a room where a section of the population will want to negotiate with government on these issues.
Thank you. Now, Honorable, transitional clauses are common, but if someone cross-checks for me, I think cat is also banned under the National Drugs Act. Please, I just check. I just said check, okay, to be sure. If the Solicitor General can check for me, so that when you're providing for a transitional clause, it's a transitional clause for an accepted product. Mhm. Do we need a colleagues? Do we need a transitional? Yes. Do we need a transitional clause for products really? That you are saying the minister is going to license? Yes. I want first put a question on Honorable Chivumbi's proposal. Yes. Okay. Honorable Minister.
I think, Right Honorable Speaker, we are jumping the gun because we stood over interpretation. What is a drug or narcotic substance? Number two, I think we stood over also the matter of when this law comes into force, whether on assent or after some time. And I think the idea was the advocates of a transition were the ones against immediate enforcement of this law. So could we now determine that one, and then in a way it will answer this question?
You see, colleagues, I'm very, very cautious. Okay, I don't want the debate of cut to be the one we go on here. Okay? And yet it is going to be on the schedule. Yeah, until we reach the schedule. Okay? So I really, let us handle this clause the way it is. Once we handle the schedule and we allow whatever is being proposed, then a member can recommit this clause and we look at it.
Chair, I think yesterday's, I know the Attorney General is not here. You elaborately sent us behind, and that led the move of the minority report to literally withdraw that report, because we had very elaborate negotiation over the transitional period. And that's why the matter was not contentious at that time. So in my humble view is that as we move, as long as you commit, you will permit us to recommit this provision after the schedule, that is fine. As long as you make a commitment that you will permit us to recommit the schedule, it's fine.
So Honorable Chivumbi, what you are saying, if I pick you very well, you're saying within the regulations, the minister may determine, isn't it? The date. Yeah, but that's fair, Honorable colleagues. Yeah. That's fair. That's fair. Honorable colleagues, I put a question that clause 90 be amended as proposed, also covering Honorable Chivumbi's proposal. Those in favor say aye, and the contrary nay. The ayes have it.
Clause
now,
90 as amended.
A transitional clause is not bad. Let us, it will be managed for people who have been having their plants and now you want to license. Even in the old law, it had been there. Because I was seeing in the annulled law on regulations, which was under section 89, determining the date for the enforcement of the prohibition of growing and dealing in Casa Eduris. And, you know, so...
Clause 90 as amended.
I put the question that clause 90 as amended stands part of the bill. Those in favor say aye and the contrary nay. The ayes have it.
Clause 91.
I put the question that clause 91 stands part of the bill. Those in favor say aye and the contrary nay. The ayes have it.
Clause 92.
I put the question that clause 92 stands part of the bill. Those in favor say aye and the contrary nay. The ayes have it.
Clause 93.
Put the question, clause 93. Honorable Jonathan Odu.
Chair, on 93, 2, I have reservations on the powers we are giving the minister to amend these schedules. Because in the schedules, we have listed so many.
If you don't mind, we can first get a report of the Committee on Health, then Chair, Committee on Health.
Thank you very much, Mr. Chair. The committee proposes to amend clause 93, but subclause 2 by substituting with the following. The minister responsible for health, may by statutory order in consultation with the National Drug Authority amend the 2nd, 3rd, 4th, and 5th schedules in the Act. The justification is A, the National Drug Authority is clothed with a mandate under the National Drug Policy and Authority Act, CAP 206, to approve the list of essential drugs and the revision of the list in a manner provided by the Minister. Under the Act, the Minister who supervises the National Drug Authority is the Minister responsible for health. B, it is logical that the Minister responsible for health takes charge of the function of approving the amendment of schedules.
That's Honorable Jonathan. You wanted first comment?
I know the Minister of Internal Affairs will come in, but the proposal, the Minister may by statutory order, is that word order or statutory instrument? Isn't that a new, do ministers issue statutory orders?
Okay, statutory instrument. That's what you're proposing. Are you okay with that, Honorable Chair?
Most obliged, and I'm in agreement. Thank you.
Honorable Minister.
It's the convention. I have no choice but to concur.
Thank you. Honorable Jonathan Odu. Then Honorable Nambish.
Chair, I agree with the amendment, but I wanted this particular amendment to be approved by Parliament because we are talking about the schedules, and you know the list of the items in the schedule. Some of them, if you read the mood of the House, would not want the Minister to sit somewhere and say, I've removed this
So
one.
can you add, can you propose drafting?
Yes. So it would then read that the Minister may by a statutory instrument approved by Parliament.
Yeah. Thank you. Yeah. I hope that's okay. Okay. No, Nambes, you heard? Well, this is a...
It concurs with the Honorable Duru's proposal, but actually, if the Minister would be allowed to determine which plants or substances are prohibited in the 2nd, 3rd, and 4th schedule, and even if we were to read the Constitution, the mandate given to Parliament 79, Article 79, 1, even when delegational powers to make subsidiary legislation would not allow the Minister to legislate what Parliament has legislated. This is literally what we were going to do.
But we have now...
okay, now it is...
Thank you. Honorable colleagues, I put a question that clause 93 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 93 as amended.
I put a question that clause 93 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. Ayes have it.
Clause 94.
I put a question that clause 94. Oh, sorry, Chair.
Thank you very much, Chair. The committee proposes amendment of the National Drug Policy and Authority Act. Amend clause 94 by deleting the figures 26, 29, 60, subclause 1, B and C, and insert the word "and" between the figures 48 and 49. The clause will read, Sections 47, 48, and 49 of the National Drug Policy and Authority Act are repealed. The justification, A, Section 26, subsection 1 of the National Drug Policy and Authority Act empowers the Minister by statutory instrument to make regulations restricting persons who may supply narcotic drugs, thereby controlling the supply of those drugs. Deletion of this section will leave a gap which will contradict the international conventions. B, Section 29, subsection 1 of the National Drug Policy and Authority Act, CAP 206, authorizes medical practitioners or dentists to keep record in the prescribed form all persons who are addicted to any drug specified in the 1st or 2nd schedule to this Act, and shall at least every year make a report to the Minister specifying the names of those persons and the drugs to which they are addicted. The deletion of the provision will negatively impact the Minister of Health in instituting an effective national program for monitoring and rehabilitation of persons with substance abuse disorders in the clinical context. Thank you.
Thank you. Honorable colleagues, I put a question that clause 94B amended as proposed. Those in favor say aye, and to the contrary nay. Aye. Ayes have it.
Clause 94 as amended.
I put a question that clause 94 as amended stands as part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 2.
Honorable colleagues, we agreed to stand over clause 2, which is interpretation. Oh, do you have a new clause?
After 94.
After 94, Chair Defense is proposing a new clause.
Thank you, Chair. Right Honorable Chair. The Committee of Defense and Internal Affairs proposes to insert a new clause immediately after clause 94. Repeal of Narcotic Drugs and Psychotropic Substances Act of 2016. 1. Narcotic Drugs and Psychotropic Substances Act 2016 is repealed. 2. The statutory instrument made under the Act repealed under this section, which is in force immediately before the commencement of this Act, shall remain in force so far as it is not inconsistent with the provisions of this Act until it is revoked by the regulations made under this Act. Saving provision. A license issued under the Narcotic Drugs and Psychotropic Substances Act.
No, that's also a new clause or under the same, because
it's the same.
Yeah, because you see.
Oh.
You see, Chairman, you're referring to a law that was nullified by court, so it's not in existence. We have nothing to repeal.
Okay. Nothing to save. You see?
No, but there is nothing to save because court nullified it in its entirety, including the regulations and everything.
Okay.
Yeah.
I stand to be guided.
No, that's this is very clear, Honorable. There is no need for any argument. Please, no. Court nullified. Yeah. Yeah. So nothing to even submit because there is no law. Yeah. So, Honorable Chair, let's go to clause 2 on interpretation. Honorable, let me first check. Honorable Gori, what's the issue you wanted to raise?
The issue I wanted to raise, Chair, is the precedent we have made as Parliament. And it is consistent with what the Chair is trying to put. That because whereas that law was thrown out by court, but the precedent we have made is that whenever we now come up with a law, we at least set the time when after assent, when the general regulations would come out. That's why I was pushing for, under regulations 90, to insert a clause that since now this is 2 ministries handling this, maybe we would give them 120 days after assent to come up with the general regulations for the implementation of this law. Just like we did for the social security when we gave 90 days and regulations came out. Because now he's trying to save even, he was trying to save even the regulations that were quashed by.
Yeah, but
by
Honorable, the procedure is you can recommit a clause. We left 90 a long time ago. Okay? So you can recommit and you give your proposal.
Thank you.
Yeah. So you got clause 2?
Chair, before we come to clause 2, I remember yesterday we stood over clause 6 and there were interpretation issues around clause 6. So maybe we resolve 6?
No, we couldn't handle 6 because we had not handled clause 2. Because of the word precursor. On 6 we had the word precursor, which needed to be interpreted under clause 2, which is the interpretation clause. So we must start with clause 2, then we'll go to 6. But we don't have the word precursor. People said we cannot, how do we discuss what is not yet defined? That was the argument. Otherwise, we would have handled 6 yesterday. Yeah, that was the only issue. So let's interpret The moment, because precursor was a new terminology, okay, being brought in. Once we accept it, then we can handle 6 with it. So let's go on clause 2, and then we also handle 6. Okay? Yeah. Chair.
Thank you, Right Honorable Chair. Clause 2 of the bill deals with interpretation. Clause 2 is amended 1 by substituting for the definition of the word bank the following. Bank includes A, financial institution licensed under the Financial Institutions Act 2004, B, microfinance deposit-taking institution licensed under the Microfinance Deposit-taking Act 2003, and C, a microfinance institution licensed under the Tier 4 Microfinance Institutions and Monetary Lenders Act of 2015, and D, the Bank of Uganda. 2, by substituting for the definition of the word kata idulis the following. Kata idulis means the kata edulis plant. By substituting for the definition of the word currency point the following. 33. The currency point has the value assigned to it in the first schedule to this act. 4. The definition of the word illicit trafficking in paragraph B by substituting the words cat plant with the word katha edulis. 2. By deleting paragraph C. 4. By deleting the definition of the word medicinal opium. 5. No, the other one was 5. 6. By deleting the definition of the word ministry. 7. By substituting for the definition of the word produce the following. Production, where the reference is producing a narcotic drug or psychotropic substance, means the separation of narcotic drug or psychotropic substances from the plant from which the narcotic drug or psychotropic substance is obtained. 8. By insertion, the following definitions in the appropriate order. Facility for treatment and rehabilitation includes the health unit as defined under Medical and Dental Practitioners Act. Medical purpose means the use of a narcotic drug or psychotropic substance for treatment or research that is provided by a medical practitioner, dentist, pharmacist, or veterinary surgeon, while acting within the usual course of professional practice and in accordance with a standard of care generally recognized and accepted within the respective profession. Cut means the leaves, twigs, or the bark of the Katha edulis plant. Substance use disorder means a pattern of psychoactive substance use that appreciably increases the risk of harmful physical or mental health consequences to the person using a narcotic drug or psychotropic substance, or others to an extent that warrants attention and advice from health professionals. Right Honorable Chair and Honorable colleagues, justifications for the above are: 1, the amendment to the definition of the word bank is intended to expand the definition to cater for all financial institutions as currently existing in Uganda. 2, the amendment of the word currency point is intended to harmonize the definition of the word with its usage in the bill, especially in Schedule 1, where a value of a currency point is assigned instead of a meaning as indicated in the definition. 3, the amendment to the definition of the word kata iduris is intended to harmonize the usage of the word and its definition. 4, The amendment proposed to the word illicit trafficking is intended to harmonize the definition with the definition of the word drug trafficking, and also to harmonize the definition with the use of the word cat. 5. The deletion of the word medical opium and ministry is intended to remove redundant words which are not used in the bill. 6. The substitution of the definition of the word produce for production is intended to harmonize the definition of the word and its usage in the bill. 7. In the definition of the word trafficking, the deletion of the words is intended to remove criminal liability to a person who holds out as possessing a prohibited drug when not, since the possession of a prohibited drug is a matter of fact. Extending criminal liability and punishment to a person who has not actually trafficked a prohibited drug, a prohibited narcotic drug or psychotropic substance, is harsh and absurd. 8. The insertion of the definition of the words cat and medical purposes is for clarity and to define words which are used in the bill without definition. I submit.
Thank you. Chair, Committee on Health.
Thank you very much, Chair. Clause 2, interpretation. The committee proposes the following amendments. A, by deleting the definitions of the word addict and minister. B, by inserting the following definitions appropriately. Precursor means any substance specified in the 5th schedule or anything that contains any substance specified in that schedule. The justification, A, to eliminate redundancy created in the bill by the word addict since it has been substituted with the words substance use disorder. B, to avoid confusion in reference to the two ministers referred to under the different parts of this bill. Therefore, it is best we clarify the minister being referred to in each particular part, either the Minister of Health or the Minister of Defense and Internal Affairs. C, the bill is introducing a new schedule to provide for precursors. It is therefore important to give meaning to the word. Thank you.
Thank you. Now, colleagues, we shall go one by one, okay, on the proposed on the proposed definitions. So, one is on bank. I put a Honourable Minister, are you okay? We are going to go on definitions. Now, I want us to go one by one. I don't want to carry the whole clause, and we end up
Agreed.
making mistakes. Thank you. I put a question that the amendment to the definition of the word bank. Okay, I want to put a question that the definition of the word bank be amended as proposed. Those in favor say aye, and the contrary nay. The ayes have it. I'm sorry, I will change even the procedure because I want us to go one by one. I don't want to bundle. Okay? The next one was Kasa Idris. I put a question that the definition of the word Kasa Idris be amended as proposed. Those in favor say aye, and to the contrary nay. Aye. The ayes have it. The next was currency point. I put a question. I put a question. Just I put a question that the definition of currency point be amended as proposed. Those in favor say aye, and the contrary nay. The ayes have it. Medicinal opium. What's next? I put a question that the definition of medicinal opium be deleted as proposed. Those in favor say aye, and the contrary nay. Ayes have it. I put a question because we had minister. Okay. I put a question that the definition of the word minister be amended as proposed. Those in favor say aye, and the contrary nay. Aye. Ayes have it. I put a question that the definition of the word ministry be amended as proposed. Those in favor say aye, and the contrary nay. The ayes have it. I put a question that the definition of the word ministry, production, be amended as proposed. Those in favor say aye, and the contrary nay. The ayes have it. I put a question that the definition of the word I put a question that the new insertions be inserted, new definitions be inserted as proposed. Those in favor say aye, and the contrary nay. The ayes have it. Yes, Chair. Because I had not yet finished. Yours was on no.
Insertion the following definitions in appropriate facility for treatment and rehabilitation.
You didn't propose the new insertion?
No, but I disagree with the proposal by the committee.
On insertion?
On facility for treatment and rehabilitation. The facility for treatment and rehabilitation includes a health unit as defined under the Medical and Dental Practitioners Act. Mr. Chairman, treatment and rehabilitation centers are under the Mental Health Act, not the Medical and Dental Practitioners Act.
I put a Chair, you okay?
I agree to the improvement.
I put a question that the amendments and the new definitions be honorable clarification with let's move under if it's under the Mental Health Act. Now what do we I put a question that colleagues, I've sat here for a long day. I want us to capture where it is provided for under certain law. We are just cross-referencing. We are adopting. There is nothing much to do. So I'm going to phrase it in a way that the record captures it, then it will be cleaned up by the clerk and the drafting team. Okay? So I put a question that the proposed new definition and amendments by the chairperson committee on health be adopted. Those in favor say aye, and to the contrary nay. The ayes have it. The record will capture very well. Yeah. Yes, Honorable Nandara.
Mr. Chairman, I'm looking at definition also. Now, here I see we have defined a bank.
But Honorable Nanda, where are you?
No, Mr. Chairman, just give me just a...
I'm also asking a question like how you. Where are you? Honorable colleagues, I put a question that clause 2 be amended and Honorable Joan, okay.
Yes, Chair, on the definition of illicit trafficking, Part A, there's a part that says cultivating any cocoa bush or gathering any portion of a cocoa plant. I have a challenge with the word gathering because I'm a youth worker and many times we go on retreats with youth. And as they enter premises, we collect from them. We tell them, If you come here, we will check you for drugs, and we collect from them. And I see that this word gather is in two places without a clear definition. So me who is gathering from these youth could be, yes, so I propose that either we extend and say gathering for illegal use, or we actually define the word gather.
Chair?
The committee specifically used the word gathering with respect to planting. There are those who say cultivation or planting of that. There are those who say, I did not plant, but we say if you gather what you did plant, as long as it's a prohibited plant, you also.
Now, you cannot gather an illegal item for proper use. Okay? Yes. So, Honorable Ayume, what the Honorable Joan Okia is raising is for you people who are in that profession, the ones you've been catering for. Is she in a problem if she's getting from youth that are turning up, okay, and are having these drugs and confessing and...
That question is because cultivating is already defined and harvesting is included in cultivating. But gathering is not very clearly defined. And yet gathering is a general word which can mean harvesting, but it can also mean collecting items together in one place. So we either define what gathering means as per this clause, or we expound it to say gathering for maybe illegal use as prescribed in this bill, or as described in this bill.
Chair, it points back to your guidance that we cannot gather an illegal substance for illegal use. But, for example, it can be gathered for destruction. I think I am persuaded by Joan to put a limit on what the gathering would entail so that it turns out criminal. But on a general perspective, we are too general, and we may capture innocent people who are doing it for a genuine cause.
Because I thought the people who can correct this, who can deal with addicts and what, are already provided for in the law. Now, if you open it up to the whole population, what are you going to have? Honorable Chibadia?
Thank you, Chair.